give me 1 moment, Mr. Singer.
Retail Limited and Newcastle United Football Company Limited and another.
Sorry, just give me a second. I've got a bit of a computer problem here. Yeah. Sorry about this. It's going to take a second. I've got to reboot it. Bad hair day, I'm afraid. Yeah, I'm afraid I'm going to have to just rise for 5 minutes. The computer has decided not to work at all. See you in a minute.
Make an application for weeks off, then I will be behind you. All square.
Yes, Mr. Singler, just give me a few seconds. And then we should be cooking with gas. Yep. Well, thank you very much. Off you go.
Good morning, my lords and my lady. As you know, I appear on behalf of Sports Direct with Mr. Cuppin and Professor Bailey. Mr. de la Mare and Miss Berridge appear on behalf of Newcastle. First of all, could I start by thanking the court for accommodating this matter on an expedited basis? Your lordships will have seen the reasons for seeking expedition. Now, subject to the court, I was proposing to make my submissions on a rolled-up basis. And in view of the time, I think we've agreed that we'll broadly split.
Right. Can I just say, first of all, if the parties need it, we can sit all day today. Secondly, we regard this as a fairly important application for permission to appeal, and so we don't want to rush anybody on either side. But obviously, it's an interlocutory matter, and it's obviously urgent. So we would like to hear your submissions, obviously fairly succinctly, but don't assume you've got to be done in half an hour or something.
I'm very grateful.
I mean, if you could, if you can be done in, say, 2 hours, and we can allow Mr. de la Mare 2 hours, and you can have half an hour for reply, that would be fine.
I'm very grateful. I've obviously prepared on the
Sorry,
bit.
sir. It's not coming through. Is it possible to move the microphone just in front of your box there? Can I come over and do that? Sorry to interrupt. Yeah. Is it possible to... No? Yeah. Can it go on that bit there? Yeah. I think that'd be too low. Apologies.
No.
Because you need your...
That's to be for knocking
Needs
that
to be
off.
directed on the thanks. Sorry.
My lord, that's extremely helpful. Could I just take a moment to sort this out?
Don't move forward.
Yeah, if you could just lean into the mic. I mean, talking
No.
to...
Can you?
Sorry, my lords.
Well, I
could
mean,
I just have
the most important thing is that we hear,
Yeah.
and although a transcript has been permitted, the providing of a transcript is not going to be permitted to disrupt the hearing. So, Mr. Singler, please carry on. Anybody who wants to mess around with the microphone can do so, but we need to get on with this hearing.
Yeah,
Thank you
but if
very
you
much.
could just speak into the microphone, please.
Yeah, I'll do my best. My lord, that's
Could you
extremely.
twist it towards you, or else I won't be able to do the real time feed either.
Who's doing this transcript?
Is it okay?
My lord, that's extremely helpful in terms of time. I've prepared my submissions obviously on the basis that we only had this morning, and we've cut the number of authorities on that basis, but nonetheless it would be
Well,
helpful.
I don't think there is a need for a great reference to authority, but I do think that we need to hear at least proper argument on the question of, I mean, the two serious questions, which are serious case to be tried and balance of convenience.
Exactly, my lord, and it's very helpful to know that I don't need to rush through those matters. Balance of convenience I can take relatively briefly because the points are short. They are important, but they're short. But serious issue to be tried with respect that we say that the tribunal has fallen into error in a number of respects, and so it's helpful to have a time.
Yeah.
Can I ask you, first of all, because it seems to me, speaking only for myself, that there is a fundamental inconsistency between ordering a speedy trial in very short order and holding that the case is really strikeable because there's no serious case to be tried, therefore there's no serious case, what's the point in trying it?
Onto a speedy trial.
Yeah. So,
My lord, we absolutely agree. And
well, it's not agreement I want, it's, can you tell me what precise directions have been made for the trial of this matter by the CAT?
Yes, my lord, the position in relation to that is a defence has been served by the club. That was this week. And there is ongoing discussion between the parties and indeed the tribunal as regards the subsequent directions. The tribunal's position is that the trial should be expedited
I can't hear you, sir.
and needs to come on urgently.
I can't.
I'm sorry, I can't have this hearing disrupted by the transcript writers. If you can't write a transcript, please don't bother, because we don't need one. What we need to do is have a fair, just hearing of this matter. And I have a lot of this. This court is being live streamed, it's available online, and we will know what is said. And if you have not set up the technological arrangements for the transcript in advance satisfactorily, I'm afraid you will have to do your best. Thank you very much. Please remain silent.
Please tell them.
Thank you very much.
I can't do it.
No, well then don't do it, please. Thank you.
My lord, I'll try to keep my voice as
We've got an order from. Have we got a?
It's just the direction of the microphone, and I'll be able to hear you perfectly. I'm sorry it hasn't been set up correctly. That wasn't my responsibility.
Yes.
But if it's just
We will
terminology,
now
I can
cease.
hear.
We will now cease by order of the court to discuss the transcript. Mr. Singer, please continue your submissions.
Yes, my lord, I think you're asking me about the timetable.
Yeah, no. I was asking whether we had in the bundle an order from the CAT, or is there yet to be an order?
There's yet to be an order, but there is ongoing correspondence as regards the directions. But to be clear, both parties and the tribunal are proceeding on the basis that there will be a trial, and directions are the subject of ongoing discussion.
Is what's contemplated a trial by the end of the summer term?
Well, not by the end of the summer term, my lord. Our position was originally that the trial should come on in September. That may have moved slightly to October. The current dispute is October or January. But JD Sports has recently been joined as a defendant.
Oh, I saw
and
that.
so the timetable discussion will now need to factor in their involvement. So I can't
So
say...
you're talking about a trial in January?
Well,
No, the debate, exactly.
October or January.
Our position is the trial should come on as quickly as possible, that being October. The tribunal, from the correspondence we've seen, seems to be on board with the idea that this is urgent, because your lordships will appreciate the question of next season's kit is why we're seeking the injunction, the interim relief. What we cannot have, with respect, is a situation where the timetable gets pushed back to such an extent that we're now faced with 2 seasons worth of kit. You may have picked up the timing issue in terms of when the kit needs to be ordered. There's a lead time, so that the window is October to December. That's the club's evidence as to
Is
when.
that October to December for the 25-6 season?
Exactly, my lord. And so that's why we say we've had to bring an application for interim relief, because we only learned about the JD exclusive agreement on the 12th of February of this year. There was, we say, a great deal of lack of transparency. But by the time the club eventually told us that they had signed an exclusive deal, some months after it had been signed, next season had become a fait accompli. That was their position. They were saying, well, you now can't apply for interim relief. Our position is we need the interim relief to ensure that we are supplied for next season.
So this season, you can't get kit?
For 24 to 25,
Yes.
that's the season which we have been foreclosed from, as it were.
Right.
And
So this concerns next season only?
as long as the trial comes on sufficiently early.
Yeah.
Because, my lord, if the trial, let's say, if the trial were to come on in October, then there would be, it would be tight, but the hope is that there would be a judgment in sufficient time for matters to be resolved and the orders to be placed for the following season, 25-26. If, however, the trial were not to be listed until, let's say, February 2025, it would then be too late if we succeeded at that stage.
But what I don't understand at the moment is, you say you've been foreclosed. Why did you not apply for an injunction earlier when the foreclosing was taking place in relation to the 24-25 season?
Well, my lord, the short answer to that, and I will come back to this, the short answer is that there was a complete lack of transparency, and I'll show you the correspondence. We were not told that they had signed an exclusive deal until the 12th of February. This is really quite important, my lord, because your lordship will have seen the respondent's notice point seeks to resurrect a delay argument, And we say that's hopeless because there was actually some very disingenuous correspondence, which I'll have to show the court. As late as the 25th of January, the club was telling us in correspondence that they were still considering our order.
I can see how that might have a bearing on one of the two ways in which you put your case, the anti-competitive agreement. I don't at the moment, and it's probably my fault, see how that helps your case in relation to abuse of a dominant position. Because as I understand that is based on the fact they ceased to supply you, and you must have known when that happened.
No, my lady, the evidence on that is that there were discussions between Sports Direct and the club going on in as late as December.
Right.
In which it was not said definitively, we will not supply you. And that's the discussion with Amanda Staveley that you may have seen referenced.
I think that's the point you just made, isn't it? That as late as the 25th of January, they were still talking about the possibility of supplying you.
Well, exactly. I mean, the chronology is important, but just to be clear, they had done this deal in October of last year.
The deal with JD Sports.
Exactly. The result of which they say is that they can't supply us because they've got an exclusive deal. They did not communicate definitively that they would not supply us until the first quarter of this year, the January and February correspondence. Indeed, in January, 25th of January, it's in the bundle and I'll come back to it, they were writing correspondence to the club saying, we're still considering your order. How they could have said that when they'd already signed the agreement back in October is completely unclear to us. But what that does mean, with respect, is that we cannot be criticised for not having applied for interim relief sooner. And that's very unfortunate, the way the club has handled this matter, because the ordering window, I mean, this is all in the evidence, but the lead times mean that the orders need to be placed between October and December. There's a debate about whether it's that wide or whether, in fact, the orders need to be placed in October. But on any view, we were not told that they had signed an exclusive deal and, to answer my lady's question, the refusal to supply.
Yeah.
They were having discussions in December, just before Christmas, saying, we'll come back to you, we'll have another meeting and so on. That, in the event, didn't happen. But that's why we've been left in this invidious position. And that's why, to answer my Lord's question, next season is now a fait accompli, subject to interim relief. And that's why the order that we seek is essentially, they have placed their orders for kit, and the order that we seek, jumping ahead, is essentially that they, assuming we meet the various criteria, what should now happen is there should be a diversion, because what we've ordered is a fraction of what the club itself has ordered. So we've ordered 50,000 odd items. They've ordered 350,000 odd items. And so jumping ahead, the form of order that we seek is essentially a pro rata diversion. What they are due to receive, having placed their orders on time, we say that we should receive by way of mandatory injunctive relief.
So that's a pro-rata diversion of kit for 25-26, not 24-25.
No, for 24-25.
24-25.
Because for 24-25, the club placed an order for 350,000 items. Those are due to be delivered, and we have the delivery schedule. But no orders were placed by Sports Direct. Well, sorry, an order was placed by Sports Direct in December for 24-25, but that's the order that's been refused. And so what we...
How big was that order?
That was the 50,000 odd items, my lord. And so that's why our only way of ensuring what we say is the status quo is continued to get supply for next season's kit, because the court may have picked this up, but the launch date of the kit is actually some way in advance of the football season. So, for example, the home kit is due to be launched on the 7th of June.
Of this year?
Of this year. Very, very soon. That's the expedition.
So just after the 23-24 season ends, the home kit for 24-25 is...
Exactly, my lord, and that's why it's deeply unsatisfactory not to have been told about the exclusive agreement, or indeed the refusal to supply, until January or February this year. It's hopeless, with respect.
But just to be clear, this injunction that you seek does affect the kit for next season, 24-25, as well as the ordering for 25-26.
No, my lord. On the latter point, the hope is that the trial will come on sufficiently early, such that if we are successful at trial, we can place an order in the usual way. so that we won't need for 25-26. For argument's sake, let's just say that the manufacturer will require that order to be placed in October of 24. The hope, at least on our side, is that a trial could come on in sufficient time, that a judgment could be delivered, so that if we were successful, we could then place the order in the usual way.
So the injunction you're asking this court to impose relates to 50,000 units for 24-25.
Correct.
And for delivery by June, because that's when the strip first goes on sale, normally at the beginning of the season or in advance of the beginning of the season.
That's correct, subject to a nuance, which is that there are 3 types of kit. There's home, away, and I think a third strip.
Yeah.
And there are different launch dates. It's staggered. Right. And as a result, the delivery dates are staggered. But in broad terms, my lord, yes, you've captured.
Okay. Well, I've understood enough, probably.
Yes, no, exactly. But can I just make this point, that the timetable, as I say, we are pressing for a trial to come on very urgently, but the timetable has not yet been fixed. And what, with respect, we cannot have is a situation where we're refused injunctive relief, the trial somehow goes back to the first quarter of next year, and then it becomes a 2-season issue as opposed to a 1-season issue. I hope that...
So on what terms are you asking that they sell you kit, 50,000 units of kit? Is it the same terms as last year, or what?
It's the wholesale price, my lord, that is payable to the manufacturer of the kit is the same, whether it's paid by the club or by Sports Direct. So the precise mechanics of the order are something to be drafted, because there was some discussion about this at the hearing in front of the tribunal and subsequently. But in broad terms, we have a delivery schedule. But perhaps I can show you, this might help at the outset, just to show you, my lord, the table. If your lordships have the supplemental bundle, and if I could ask you to turn up page 312.
314.
312, please, my lord.
Oh yeah.
Now, I hope this will assist. This table, and one can ignore the red rows for the time being, but the table sets out those items of kit that Sports Direct placed an order for in December, the order that was refused. And your ladyship will see that the SD order product code and SD product description. So, for example, the first row is the Adidas Newcastle home shirt. Shorts. And then you'll see the quantity that's been ordered, which is 610. So SD has ordered 610 of those items. The club, however, has ordered 3,600 odd of that same item. And the club is due to receive those items in 2 tranches, tranche 1 and 2, with the quantities to be delivered in each tranche. And as you'll appreciate, they've front-loaded that, because obviously the home kit launch date is the 7th of June. So the vast majority is going to come in the first tranche. And then you have the estimated delivery dates. So that's Adidas delivering to the club. Sorry, no, that's to the warehousing facility. And then the last column is estimated delivery to the club. And so this is actually a point that the tribunal did agree with, that the injunction that can be workable, as it were, because we're seeking essentially a diversion. The club's due to receive all of these items that we have ordered. The club's ordered a lot more than what one sees in this table. This is just the 50,000 items.
Where did the tribunal say that the injunction requested was workable?
My lord, let me just... it's paragraphs 32.2 and 34.4. As I say, there was discussion during the hearing of exactly what the order would look like.
32.2
of the judgment, and 30... it's internal page 20 of the judgment, my lord.
Yeah.
And you'll see Mr. de la Mare was arguing that the terms of the injunction were too intrusive. This is, I think, not a point that he's pursuing before this court. And the court goes on to say, we accept both of these points as valid, but they could, were we minded to grant an injunction, be dealt with easily in the drafting of the order, make provision for Newcastle's costs, and priority of supply could be resolved by obliging Newcastle to transfer a fixed percentage, as and when received. They are resolvable in the drafting of the order. And
You said 34 something.
yes, my lord, 34, subparagraph 4. Where they say they would have significantly reworked it so as to make it practical and workable as possible. That's about 2/3 of the way down. Yeah. And so that I'm clear, my lord, we've been approaching this appeal on the basis that the mechanics or the precise drafting would be a matter not for this court, but to be dealt with subsequently. So, but there was a lot of argument by the club that this was just impossible to.
You say this has now to be accepted because it's not the subject of a respondent's notice.
The workability, yes, my lord.
Yes.
Exactly. Exactly.
There's one caveat, isn't there, which is that they say that they have concerns about the degree to which the order would have to be supervised by the tribunal.
They do say that, my lady, but the ultimate conclusion is that this can be dealt with in the drafting. It's a minor point it's referred to at in the penultimate line of that paragraph.
And when they say that we would have significant deciding, so there isn't a draft, is there? Where's the draft of the order you're seeking?
The draft in the bundle has not been updated to reflect the discussion which took place at the hearing and subsequently to the hearing, subsequent to the hearing.
But you've got two juniors, and I would suggest that if you intend to ask this court to make an injunction, you tell this court what injunction you're seeking.
Yes, my lord.
And in pretty short order, Mr. Singler.
We would like to have a draft.
Yes, my lord. We can produce that. As I say, we've been approaching this on the basis that this court would deal with the points of principle, and then the tribunal would have to any actual injunction.
Unfortunately, if you think that we can avoid getting our hands dirty in an application for an injunction which the tribunal has refused, I'm afraid you're probably mistaken.
Hey, my lord, I do apologise.
I think the injunction. Were we to be in your favour, I think we would be looking to make an injunction in this court.
Yeah.
Well,
not to leave it to the cat.
I'm grateful. I'm not sure that we had anticipated that this court would actually make the injunction order.
I'm not saying we do anything, but I mean, if we did, speak for myself, I would expect us to be making the order. So
That would be the normal course if you
I
were
think
allowed
it might be
appeal.
sensible if your juniors started preparing something.
Yes, just to be clear, there is a draft order in the bundle. The only respect in which it needs to be tweaked is the priority point that we saw in the judgment. So there is a draft order in the bundle.
Okay, where is it?
My lord, it's in the supplemental bundle behind tab 18,
Page.
page 150. And if your lordship, your ladyship has page 151, paragraph 3, you'll see that the order is by no later than the 6th of May. And what we now need to reflect is the staggering, if I can put it that way.
My lord, if I could just rise for a moment just to indicate that we would in particular find it extremely helpful to have a draft order. The draft order that is in the bundle was in fact superseded by a further draft that was produced to the CAT, which hasn't unfortunately made its way into the bundle. There were a number of points on practicability discussed which any order would have to reflect in any event. point 1, the extension of the cross undertaking to JD Sports and Adidas are all potentially caused harm by the grant of the relief in question. Point 2, the fact that any kit received couldn't be sold in advance of launch, effectively querying the pitch for any particular launch.
There's a bit of competition outside, Mr. de la Mare. Can you speak up a bit?
Yes, that any kit that he's, of course, any kit that he's supplied should be subject to the proviso that it couldn't be put on the market before the club's official launch date, because one couldn't have a situation in which that occurred. And then my learned friend would need to come off the fence, because what the CAT was proposing was relief very different to the relief sought by my learned friend. My learned friend was seeking supply of the full 55,000 items, which is a level of supply reflecting the exclusivity, the practical exclusivity they had previously. The CAT was proposing a different metric. It was a kind of judgment of Solomon, which is that you should get a percentage. I think the percentage was 10%. And whenever stock arrived, you should immediately pass on 10% to Sports Direct. Now, I don't know, and it would be extremely important for us to know, where my learned friend is in terms of what he's actually seeking, whether he's seeking the CAT solution, his original order, or some variant thereon. His original order is riddled with problems, not least that the last draft sought delivery of kit before we would ever receive it.
My Lord, in view of the time, can I say we will produce an order over the lunch adjournment? It's very grateful that the court could sit beyond 1 o'clock. The short point is that the principles have all been debated and set out in the correspondence. We can very easily produce a revised draft order for the court.
Okay.
But I obviously conscious. I need to persuade you on the errors in the.
Let's get on with the principles then.
My lady, in a nutshell, as you will have seen, Sports Direct has stocked Newcastle replica kit for decades, and as the tribunal accepted, at least arguably, Newcastle kit forms its own product market, and therefore Newcastle has a dominant position. But then for the next season, the club has decided to refuse to supply any kit to Sports Direct. It's going to sell the kit itself, but only in its stores in Newcastle and online, and it wants wide distribution across the UK, and so it's entered into an exclusive arrangement with JD Sports. But my lords, my lady, the net result of that is that Sports Direct will be entirely excluded from the retail market for the sale of Newcastle replica kit. And that's problematic from a competition law perspective, because JD and Sports Direct are the two main retailers of replica kit.
Did JD sell Newcastle kit before?
Yes, my lord. For the last 5 years at least, the evidence says, this kit has been supplied by Sports Direct and JD, the point we rely upon in relation to status quo. They are the two main retailers of replica kit with bricks and mortar stores across the UK. They each have in excess of 400 stores. And as the tribunal accepted, at least for present purposes, Sports Direct has a particular reputation for aggressive price competition, paragraph 29(1) of the judgment. It was prepared to accept that. So the consequence is that the exclusion of Sports Direct will distort competition in the retail market and ultimately lead to consumers paying higher prices for Newcastle replica kit. And indeed, as I'll show you, what is striking about the club's conduct is that the limited evidence that we have at this early stage of proceedings shows that it's precisely because of Sports Direct's discounting practices that the club has decided to refuse to supply any kit to it. Now, in competition law terms, the club's conduct is very well known in terms of anti-competitive conduct and how the claim is framed. It's entirely orthodox. We say, A, the club is committing an abuse of a dominant position by refusing to supply Sports Direct. Sports Direct being both a customer of the club and also a competitor in the downstream retail market. And we say that abuse is likely to lead to an adverse effect on competition in the retail market. That's a breach of the Chapter 2 prohibition. And we also say the exclusive agreement between the club and JD Sports is capable of having anti-competitive effects in the market for the retail supply of the club's replica kit. So that's the breach of the Chapter 1 prohibition. And we've discussed the need for the interim injunction, but a speedy trial has been ordered. But just to say this at the outset, it's quite common in competition cases where the alleged abuse, or one of the alleged abuses, is a refusal to supply. It's quite common for interim relief to be ordered, which ensures that the supply should continue. So whereas in other contexts, the idea of a mandatory injunction may be used to say that the court is perhaps more reluctant to grant a mandatory injunction, here, where the abuse is the refusal to supply, it's actually relatively common for interim relief to be ordered. And just to give the court some examples of cases that we've cited, the At the Races matter, one of the cases we've cited, an interim order was made there to continue supply of horse racing data. The Barclays Bank case cited in our skeleton was an example where interim relief was granted, forcing Barclays to continue to supply its services to a money remitter company. The JobServe case, a judgment of Lord Justice Mummer in this court, was another interim relief.
The job what?
JobServe, my lord.
JobServe. And where is the order for the speedy trial?
My lord, there's no order, but I think at the end of the judgment that the court talks about.
I agree, it's in the judgment, in the decision, but it's not. There's no order. Why is there no order?
No order has been drawn up, my lord, since the hearing before the CAT.
In how long?
Nearly a month.
So I don't understand why not.
27 days.
Surely you're appealing the order, not the decision. This is the way we do things here. Why is there no order?
Well, there is an order, isn't there, in relation to
Permission to appeal.
permission to appeal.
But where's the order that the CAT made in answer to your application?
My lord, I'm not aware that there is one. This isn't the first case.
We've had this point before, haven't we?
Yes, it has arisen. It arose in the trucks matter, I think.
Yeah,
the
we had it
Chancellor
in
was,
the trucks, man.
and the case had come on in relation to.
My recollection is you said that we made this precisely this point, but it was agreed that the appeal proceeded anyway. I need to check.
I think there's a question. I'm told there's perhaps a question as to whether things operate differently in the tribunal.
Well, that was the point.
Because it refers to a decision.
Yeah.
But I do understand the comment from the Master of the Rolls.
That was the point I think that Lord Justice Green and I raised
in the trucks matter. Yes, exactly.
Well, I'm looking at the rules, Competition Appeal Tribunal rules of 2015, and I mean, procedurally, it's pretty unsatisfactory. Rule 24 gives the tribunal power to make interim orders, and Rule 91 deals with judgments and orders. So if we look at Rule 91, a judgment made in collective proceedings may specify the class representative.
My lord, there is an order in the bundle. Can I perhaps?
Where is it?
There's a limit to the extent I can assist, but if one looks at the core appeal bundle, tab 7, page 47, you'll see that the CAT has made an order in relation to permission to appeal.
I saw that.
Yeah, and in the recitals they refer to the judgment but not to an order. And under the Competition Act 49(1)(a), I think the argument would be, I'm not necessarily making the argument myself, but I think the question that arose in the trucks matter was whether under 49(1)(a) of the Competition Act it's sufficient to appeal the decision. But obviously I understand the way the principles work more broadly, but I'm unable to assist, as it were, because we've obviously, our application clearly has been dismissed for interim relief. Our application for permission to appeal has been refused. It's difficult for us, therefore, to take this matter.
Well, I'm surprised that the parties have not submitted a draft order reflecting the decision to the tribunal for its approval. That would be the normal way of dealing with it.
The practice in the CAT, my lord, is that the CAT generally draws up its own orders and the parties have no...
This is the point that came up. I'm just looking at the appellant's notice. I mean, to be fair to you, Mr. Singer, your own appellant's notice says the appellant appeals against the decision of the Competition Appeal Tribunal dated the 12th of April.
Well, my lord, we were very conscious of this point, and obviously in the circumstances of urgency, and as Mr. de la Mare says, where the CAT usually tells the parties, here's an order.
So the CAT is currently, as it were, drawing up an order which would include, would it? I mean, it would include its dismissal of your present application, but would also set out directions for trial and also a trial date. Is that the idea?
That's right, my lord. And as we understand it, it is yet to rule on the issue of what measure of expedition to apply. Because while my learned friend has explained his client's position, my client's position is that we are content for a later trial to be at our risk. By which I mean that if, for instance, at the end of February next year, the tribunal directs that supply be made, we then have to supply that from our stock in any event. So my learned friend won't be at risk of not receiving stock because the orders will have gone in and the stock will, in the final context, come out of our supplies. And so there's no...
But I thought they sold strip at the beginning of the season. And the beginning of the season is... They
do, my lord. But the point I'm making is the order window is October for supply the following June. My clients will place an order in October of this year for the forthcoming season.
So you're talking about next year.
Exactly. And we are content, because we have now the best part of 15 months to plan for that contingency, we are content to assume the risk that the stock comes out of our supplies, because we can make alternatives. That's why.
Have you given an undertaking about that?
We haven't given an undertaking, but that is the terrain of argument on which the CAT is yet to rule.
Can I just say...
I'm sorry.
It would be... No, sorry, Mr. de la Mare, I'm not trying to cut you off. It's very helpful to hear your side of the story, although we'll eventually have to get down to some ordinary submissions. But the position as I see it is that we ought to have... It is not satisfactory to appeal a decision without the order. Whoever's fault it is, I would suggest that the solicitors communicate with the tribunal and say that this court has expressed a certain amount of surprise that no order has been made, even an order saying the application for an interim relief under rule such and such is dismissed. It's possible to make subsequent orders if they're waiting for further submissions and about the nature of expedition and so on. That's absolutely fine. But we would like an order, please. If they can't give one, or you can't agree it, or practice can't be followed, then you'll no doubt tell us what you hear. But it would be useful to at least ask, can we have an order, please?
Of course, I'm sure the parties can send a joint letter of
Thank you very
that sort. My lord, if I...
Given that this is not the first time the problem's occurred, I think somebody needs to get a message through that, this court expects orders to be in place, and if the CAT's making its own orders, then the parties need to make sure the CAT makes an order, at the very least, even if it's only an order dismissing your application, in good time before the Court of Appeal has to deal with it. All right.
My lord, turning back to the substance, that we submit the question for this court is whether the CAT was right to dismiss our application for interim relief, even though it accepted that damages would not be an adequate remedy for Sports Direct. Even though it accepted that, for present purposes, it was prepared to accept Sports Direct is a discounter and that therefore prices would be higher for consumers. I'll come back to that consumer harm point. And as I say, even though it was ultimately persuaded that an order could be workable, And my lords, my lady, we say the judgment contains 4 fundamental errors. First, the tribunal held that there was no serious issue to be tried. Now, we say that that was obviously wrong, bearing in mind that the court went on to direct a speedy trial and the club has put in a defence and so on. But we say the judgment is, with respect, impossible to understand on its own terms in relation to serious issue to be tried. But in any event, we say on the substance of the matter, in relation to serious issue to be tried, we say the judgment is unsustainable. And I'll obviously develop these submissions, but we say based on the pleaded case and the evidence available, which included a preliminary note from expert economists, we say there's plainly a serious issue to be tried as regards both Chapter 2 and Chapter 1. And that's especially so in circumstances where the CAT accepted that our market definition was arguable, and therefore...
That's the narrow market
That's the
definition.
narrow
Exactly.
market, the Newcastle United kit.
Exactly, exactly. Having accepted that it was arguable that our market definition was correct, it followed that the club was arguably dominant, paragraphs 12 and 27(1) of the judgment. As I say, it was also prepared to accept that Sports Direct is a well-known discounter, paragraphs 29(1) and 34(3). And we say, in those circumstances, the tribunal plainly ought to have held that the case was at least arguable. There's foreclosure, complete exclusion of a discounter, a competitor of the club in the downstream market. And my lords, I'll come back to this when I look more closely at the reasoning in paragraph 28 on the substance. But what is striking, and I want to flag this at the very outset, is that the tribunal failed to cite any case law.
Is this your second fundamental error still?
This is still within serious issue to be tried, but part 1 of serious issue is how can you have no serious issue but a trial. But part 2 is the substance. We say the reasoning at paragraph 28 of the judgment is flawed, is without any precedent, and one doesn't see any case law or any commentary or any of the European Commission guidance, for example, cited in support of those propositions at 28. And moreover...
How long was the hearing?
A day, my lord.
Yeah.
Moreover...
How long, I'm sorry, how long after the hearing was the decision delivered?
I think we had the hearing on the Tuesday, the decision was out on the Friday.
9th of April and 12th of April.
It was a bit harsh to say they didn't cite authority in massive detail in a 3-day decision, isn't it?
Well, with respect, my lord, when I come on to the analysis, what we are pleading in this case is very well established. There is a long line of authority, both European and domestic.
Which they did not cite.
Which they failed to cite. Which
and you cited.
Yes.
Yeah. Okay.
Yes. And my lord, we do say if the tribunal was going to come up at paragraph 28 of the judgment with a list of factors, it was incumbent on the tribunal to explain what the source of those factors was.
Yeah.
And I'll show the court in due course the extent to which, with respect, the tribunal has departed from orthodoxy. But also in relation to Chapter 1, your ladyship will have seen there's no analysis in the judgment, paragraph 29(3). And again, we respectfully submit that that is erroneous to hold that there's no arguable case in relation to Chapter 1, because having accepted our definition of the narrow market, we say there's plainly, at the very least, an arguable case that there will be anti-competitive effects in that market, and that's what our expert was saying in a note that was adduced before the tribunal. So on serious issue to be tried, we respectfully submit that there are some fairly fundamental errors.
Is the expert referred to in the decision, and did the other side produce an expert as well?
Both sides produce an expert note, but there is not a single reference to either side's expert notes in the judgment.
In the judgment,
yeah.
No.
Now the tribunal, as I say, that's a significant omission, because what our expert was saying, and I'll show the court this. It's quite clear the basis on which he was saying both the refusal to supply and the exclusive agreement, so Chapter 2 and Chapter 1, there is evidence of anti-competitive effect, or this conduct is prima facie, it's arguable that there will be. So we do, with respect, submit, overall, on serious issue to be tried, the tribunal has completely lost sight of the wood for the trees, because if one takes a step back, what's going on here is an arguably dominant undertaking is seeking to eliminate the largest player in the downstream market, its competitor, to sell kit to consumers in circumstances where Sports Direct has the reputation for fierce price competition. And indeed, the evidence that we've got at this stage shows that that's precisely what's driving this decision. And ultimately, we say this is utterly obvious. This is something that competition law should be concerned.
So the anti-competitive effect is the hiking upwards of the prices.
Exactly. It's the complete exclusion of Sports Direct, as the evidence shows, and I'll come on to this, which they've done because they're concerned about the discounting practices. And the tribunal itself recognised that there will be consumer harm, but simply dismisses that as an immaterial point. And we respectfully submit that that really just defies common sense in competition law terms. Now, the second, if I can just outline the second, third and fourth errors, but these are but more discreet, and perhaps I can be briefer when I make the submissions. But the second is that we say the tribunal erred in its assessment insofar as it held that damages would not be an adequate remedy for the club. And the paragraph in the judgment that we attack is 32.3. And although no doubt it will be said this court should be reluctant to interfere with the assessment of evidence by a first instance tribunal, in fact, when I show you that paragraph...
That 34.3?
32.3, my lord.
Thank you.
It's just one paragraph, but we do say that that reasoning is plainly wrong. So we're not asking, as it were, this court to reassess evidence. We're actually in the world of there being no real evidence. And the one point that they do specifically refer to, we say is an irrelevant consideration. So that's damages being an adequate remedy to the club.
So that seems to be about consumer benefit.
32.3, my lord.
Oh, 34.3.
32.3, my lord, I apologise.
Yeah, no, it's my fault.
I'll come back to that in more detail. The third point, third fundamental error, if this court's not with me on damages being an adequate remedy for the club, obviously the authorities say, well, in a world where damages are inadequate for both parties, it really becomes a question of balance of convenience, and status quo is really the key point the authorities make clear. And we say, again, with respect, the tribunal has erred in its framing of the status quo. And the short point, if I can just summarise it at this stage, is that, as this court will have seen, the club has changed its arrangements so that whereas previously it had a manufacturer called Castor, it's now changed arrangements as of October last year, and Adidas will be the manufacturer, and JD will have its exclusive agreement. But that's what we're complaining about, those new arrangements. They are the subject of our competition law claim. And what the tribunal appears to have done in 34.1 is essentially include within the status quo those new arrangements. And we say that simply cannot be right, because that would make it impossible for a claimant in our position to obtain interim injunctive relief.
I thought what they'd done is to say that the status quo was the takeover of the club by Mr. Ashley. In other words, that was the new status quo.
My lord,
No.
can I come back to this in due course? Because
Not the club, the takeover of the club, not of course by Mr. Ashley.
34.1 says the status quo is the position after the sale of the club to its new owners and their prima facie right to develop the business according to their rights. So that's looking at, what they seem to be saying is the status quo is the position when Adidas is now the supplier,
Exactly.
And JD Sports as an exclusive agreement, or what? That clearly can't be the status quo, can it?
Well, that's the point, my lord. I will come back to this if I may, because of time. But what they say is the status quo in 34.1. The status quo is the position after, they emphasise, the sale of the club to its new owners and their prima facie right to develop the business according to their rights. Status quo is not the situation which pertained when Castor was the exclusive distributor. So, in other words, and this is actually, with respect, an error that permeates through the judgment as a whole, both on the substance and also on status quo. He's effectively saying, or the tribunal is saying, that they're entitled to change their arrangements, and the status quo here, they're saying, includes the prima facie right to develop the business according to their rights. But with respect, we're complaining about the new
Well, you
arrangements.
can't complain. I mean, I'm not sure it's all one way, is it? You can't complain that the club was taken over and the new owners wish to trade in a different way, can you?
That's not our case, Mark.
No, exactly. So it's not really a question, well, it's not a real criticism to say the status quo is the position after the sale of the club to its new owners and their prima facie right to develop the business according to their rights. That's true. That is the position. The question is how important, what weight you attach to that right as against your decades-long right to buy and sell the kit. I mean, just saying the status quo is X and you stop the clock at one moment or a moment before or a moment after really is simply semantics.
But my lord, our short point on this is that one has to apply some common sense as regards what the status quo is. In circumstances where Sports Direct has sold Newcastle kit for decades, in circumstances where both Sports Direct and JD have been selling kit for the last 5 years at least, one has to take a step back and think, well, if one is talking about holding the ring between now and trial, what's the status quo for next season? My lord, and again, I do respectfully submit this is another example of losing sight of the wood for the trees, because it cannot be right that it's said against us, well, they're entitled to have some new arrangements, and really one has to look at the position framed by reference to their ability to have new arrangements, because that rather begs the question as to whether those new arrangements are the things that we're complaining about.
That I understand, but if you're looking at the position on the ground and holding the ring, as you say, you've got to stand back and look at it from a perspective of common sense. And one of the things about the position on the ground, like it or not, is that Castor are no longer making this kit. Adidas are, or yes. So if you're looking at the status quo, would you accept that you have to start on the basis that Castor are no longer your supplier,
Yeah.
no longer your manufacturer?
No, my lady, that's an entirely fair point, and actually that comes in at the substantive argument as well on refusal to supply.
I was just trying to frame for myself what you were saying the status quo is.
Yes. No,
Just to pick up on my Lord the Master of the Rolls position, with which I respectfully agree, you've got to say the club has been taken over, Mr. Ashley no longer has a stake in the club, there's a desire to change arrangements, you're complaining of the way in which they manifest that, so you can't assume that that's okay, but you can assume that this kit is not going to be manufactured by the people with whom you've had business dealings for years.
My lady, we obviously accept, and no part of our underlying complaint, is that we will no longer be supplied by Castor. I'll come on to this in the context of the Chapter 2 case, as it's put.
You say you would accept that the ultimate manufacturer can change and has changed. What you say the status quo is, if you're looking to preserve the ring, as my lady puts it, is where you and JD Sports are, as it were, joint suppliers.
Exactly. I mean, when I talk about common sense, I mean, if one's thinking about it from the consumer's perspective, for example, for the last 5 years at least, but for decades, they have been able to go into a Sports Direct shop and buy a Newcastle kit. If one's talking about what the position will be next season, because it's become a fait accompli because of the chronology and so on, we say the status quo is that we should be able to sell Newcastle kit to consumers for next season as well. That's really, there's a danger, as it were, of perhaps...
Overcomplicating it.
Exactly, my lady. That's really what we're saying. There is a danger of overcomplicating it. One has to step back, and I mean, ultimately, as the Privy Council made clear in the National Bank of Jamaica case, the question for the court on an application such as this is which course would likely cause the least irremediable prejudice to either party. So one can perhaps overanalyze these individual components of the test, but ultimately we say that the reality is decades of supply versus these new arrangements. We say the status quo is that we should be entitled to supply next season. That's our third main criticism of the judgment, and the fourth...
Is that statement by the Privy Council in the bundle?
It is, my lord. It is. It's tab 7. I'm told. I'm grateful. Exactly, it's Olin.
Yeah.
It's tab 8.
Oh, tab 8.
And the relevant paragraph that I'm referring to.
This is the case that says you shouldn't get hung up about prohibitory versus mandatory.
Yes.
Exactly, and it's paragraph 17, my lord, that I was alluding to. Paragraph 17, yes, my lord. And perhaps I should draw your attention to 16, because it said that its second sentence of 16 often said the purpose is to preserve a status quo, impossible to stop the world. But then, crucially, the purpose of such an injunction is to improve the chances of the court being able to do justice. And Mr. de la Mare says he'd like you to read 18 as well. But if I can, again, I'm still outlining our main criticisms.
Third or fourth now?
The fourth now, but this is connected. We say that the tribunal made a fundamental error in its treatment as to the relevance of consumer harm to the discretionary question of whether an injunction should be granted. And this is paragraph 34(3). The tribunal, having accepted for present purposes that Sports Direct is a discounter, they say at 34(3) that there will be consumer harm between now and trial because consumers will end up paying higher prices for next season's kit. Well, so far so good, but they then dismiss this in relation to the discretionary exercise as a neutral factor. That's how they put it, neutral factor. And what they say instead is that there may be a benefit to consumers from allowing firms to organise their supply chains in the way that they want. But with respect, again, from a competition tribunal, it's a very surprising position to take that consumer harm between now and trial is a neutral factor. Ultimately, again, if one's stepping back, the question is what would be just and convenient. That's the question ultimately for the court, whether it would be just and convenient to grant interim relief. And we say it's relevant to the discretionary exercise to look at the position of consumers.
Well, I have to say, when I read paragraph 84(3), I was puzzled by that penultimate sentence and suggestion that there was benefit to the consumers from effectively from Newcastle United being allowed to structure its distribution in the way it judges most profitable and effective. That seemed to me to be effectively saying if what Newcastle United are doing is seeking to hike the price, put the price up, then I would have thought that was capable of harming consumers rather than the reverse. But,
well, my lord, obviously we agree with that, but can I just say this? The reference there to there being some benefit to consumers from allowing undertakings to structure their distribution in the way they judge most profitable. First point is there was no evidence of that. None is cited and none was adduced. And what's striking is Mr. de la Mare in his skeleton now resorts to economic theory, when it's all completely unparticularised. But there was actually no basis to support what the tribunal said. But in any event, we would say, how could that possibly be of equivalent importance to higher prices? And that's why we say, actually, just before I get into the detail, we do say this is a very surprising judgment on a number of levels. And the points that we've identified are sufficiently hard-edged, if I can put...
Can I ask you something else, Mr. Singler, about the judgment? At various places in relation to the question of a serious case to be tried, the tribunal says that facts are disputed, sometimes hotly disputed, and says that where they're disputed, they will disregard them. As a matter of law, is it correct for a court or tribunal to disregard, as opposed to taking into account that a fact is disputed in deciding whether a case is sustainable or not?
No, it's wrong, my lord. It's quite, actually,
It's
quite
wrong
easy.
as a matter of law.
Yes.
Why?
Let me show you in our skeleton the authorities that we cite in relation to serious issue to be tried. Because they actually say, if your lordships have our, your ladyship has our skeleton at bundle 9, tab 9 of the core bundle.
Yeah.
Page internal 7 of our skeleton. Page 58 of the bundle.
So which paragraph?
I could ask you to look at 17. Allowance, I therefore approach this appeal of Lord Hoffman in 17 on the basis that the claimant's allegations of primary fact must be accepted as true. An allowance must be made for the possibility that further facts may emerge on discovery or at trial.
And is that disputed?
As a matter of law, it's not disputed. I think Mr. Delamer says it didn't make any difference to the tribunal's conclusions elsewhere.
Right.
But it's actually, with respect, difficult to understand the tribunal's approach on serious issue to be tried as a matter of law, because it does accurately record in the judgment that it's a very low bar, it mustn't conduct a mini-trial and so on. And then it goes on, as your lordship has identified, to say, but it can only look at things which are uncontentious at this stage.
Well, I suppose it's a very puzzling thing to have said, but the way one normally approaches it is to assume the claimant's case taken at its highest on the facts that are necessary to establish the cause of action, because those are the key facts. Anything else that's disputed is largely irrelevant, it's background. But the facts that are key, that are pleaded as part and parcel of the cause of action, you take as read, unless there's some kind of evidence out there which flatly contradicts it and shows it to be nonsense.
Shows it to be frivolous, vexatious or fanciful.
Exactly. In which case you're in strikeout territory. But that's the way that classically one always approaches an injunction, is to assume in the claimant's favour that that which he or she pleads will be established at trial. And then you've got this quote from Lord Hoffman, which of course says, and you can assume that there other things might come out of the woodwork in between.
Exactly. Exactly, my lady. I think there is another authority.
And this is in the context of a summary judgment, I think, or a reverse summary judgment.
Yeah.
Your point is that this is the interlocutory test,
Yes.
Exactly.
which is equally applicable to whether or not to grant an injunction.
Exactly.
Yeah.
Can I, before expanding on each of those 4 errors in the judgment, can I make some factual points about background to this matter? I'm sure the court will have read the evidence, and in particular, we rely upon 2 witness statements of Mr. Nevitt, but I'd just like to draw out a number of background points. The first is in relation to the business of Sports Direct. So Sports Direct is the largest sportswear retailer in the UK, and it has a wide network of physical stores in the UK, over 480. Mr. Nevitt's first statement, paragraph 8. And as he explains at paragraph 11 and 47 and 49, Sports Direct has a prominent focus on football as a sport, marketing itself as the home of football. And he describes football as being the heartbeat of the business and absolutely essential to Sports Direct's business model. He also says at paragraphs 8 and 11 that Sports Direct is the largest seller of replica kit in the UK. That hasn't been challenged. And for decades, it has consistently stocked replica kit of all the major Premier League clubs. Crucially, in relation to Newcastle, paragraphs 7 and 29, he says he cannot recall a year when Sports Direct has not sold Newcastle kit. It's been at least decades. And at 23 to 25 of his statement, he refers to Sports Direct's very specific strategy of price discounting, always looking to offer the lowest price for replica kits. Turning to some points about JD Sports, that's another major national retailer with approximately 400 stores. That's Mr. Nevitt at paragraph 9. And although there's very limited overlap between JD and Sports Direct, where they do overlap is replica kit. And as I've already said, for the top 10 clubs in the UK, in fact, not only Newcastle, but including Newcastle, Mr. Nevitt at paragraph 18 explains, for the top 10 clubs in the UK by market size, both JD and Sports Direct have stocked their replica kit for at least the last 5 years. And so just pausing there, and perhaps going back to the discussion we were having, if the kit was not available in the stores next season, that would, on any view, materially alter the competitive structure of the retail market to the detriment of consumers.
Why did you say they didn't overlap?
Oh, my lord, Mr. Nevitt explains they don't overlap because JD is not a sportswear retailer. It's a sports fashion retailer which predominantly sells lifestyle products with a prominent focus on footwear and trainers. That's Mr. Nevitt at paragraph 9. But on the Venn diagram, as it were, where they do, on any view, overlap is replica kit.
The replica kit, which is...
And he says that at paragraph 10. And as I say, with 400 stores each across the UK, they are really the two major retailers with bricks and mortar stores.
So, I mean, I'm sorry to misunderstand this, but sports fashion and sports kit, sports wear, seem to the idle observer, maybe judicial observer, quite similar. If I go into a shop, well, Mr. de la Mare is putting me right, and I'm sure he knows a great deal better than I imagine. But if I go into both these shops, I'll see whole aisles full of trainers, I imagine, of different kinds. Will I not?
My lord, I'm really
Not sure.
Mr. Nevitt says that they're not a sports retailer as such. I think they don't sell sporting products generally, but they're more focused on...
Which one are we talking
JD.
about? JD.
They're more
You wouldn't
focused
go
on...
in there for a tennis kit
Well,
or a cricket kit.
Exactly, I'm reluctant to give evidence.
You go
but
to Lily White's.
I think that's the point, isn't it? They don't sell things like cricket bats and stumps and so forth.
They sell clothes.
But if you wanted to buy a Worcestershire County Cricket Club replica shirt, then you might get it in either place.
Taking county at random.
Taking a county
Yes.
at random.
I think you'd find it hard to find it anywhere.
Taking the best county at random.
Exactly, and I think even with trainers, they are more focused on very high value fashion trainers as opposed to a vanilla set of running.
I think we've got the message.
Yeah,
We'll
okay.
probably stick to the evidence, Mr. Singler.
My lord, the next factual point was, as you know, there was an arrangement with Castor, and I'll come back to that later because it's relied upon in the context of clean hands. But just to be clear in relation to Castor, there was no written agreement which governed the sale of the kit from Castor to Sports Direct. And the tribunal, with respect, seems to have, the Castor point seems to have infected its thinking on both the substance of the case and also the injunction. And perhaps just jumping ahead on this, there's a debate about whether or not the Castor arrangements gave Sports Direct a 30-day period of exclusivity. I don't want to get into this now, but to be clear, so that this court is not, as it were, misled by the relevance of that point, Sports Direct is not, as Mr. de la Mare says in his skeleton, seeking to perpetuate any such period of exclusivity. So it's actually, we say, a red herring, and with respect, the tribunal fell into error by focusing on it.
Now, Mr. Singler, I said 2 hours when we started, and of course, time has gone quickly on. We should let you use the rest of your 45 minutes at your own discretion. because we do want to hear very much your best argument, but we have not got longer than the day, and we must divide the time reasonably evenly.
My lord, yes. Can I just check so that? Yeah, so I aim to sit down at 12 o'clock, but the...
Yes, I mean, 12:15 is probably okay, but that really is a...
I'm grateful, my lord.
Because we did start at 10.
I'm just going to finish very quickly on the factual points. Serious issue to be tried is where I need to spend most of my time. The other three errors I've actually outlined to some extent already, and it may be that the court has the point to some degree.
Yes, we don't go over what you've already done.
No, exactly. So can I just finish with the factual points that are material? Because the club's new arrangements are explained by Mr. Silverstone in his witness statement, and he gives evidence about why the club decided to enter into those new arrangements. And I do want to show you a document at supplemental bundle page 47 behind tab 3. So Mr. Silverstone explains in his witness statement that back in April of last year, the club engaged some consultants called Two Circles to look at this question of arrangements. And slide 20 of the presentation, he doesn't deal with this, but we've had this disclosure from the club, and this is a very important document and page in particular, because you'll see here at the top of the slide, on top of the in-house option, that's the club bringing retail operations in-house, or focusing more on the in-house option. Negotiations with JD Sports have uncovered a route for us to maintain most of the in-house benefit while de-risking our technical buy, increasing our wholesale distribution in the UK. And you'll see in the second column, JD Sports have approached us with an offer to be our exclusive wholesale partner in the UK. But then crucially, in the third column, bottom right-hand corner, going down an exclusive route, that's with JD, will limit our distribution options in the UK, most noticeably with Sports Direct, whose discount pricing model would impact our own retail operating margin significantly. And so what the document shows is that the club has decided that wider distribution beyond its own in-house operations would be useful. Mr. Silverstone says that, paragraph 32. And that's why they've done a deal with JD. But as to why they've not done a deal with Sports Direct, the other retailer with 400 odd stores, they say that's because of their concerns about the discounting model and eating into the margins. And the other piece of evidence I'd like to show you, and Mr. Silverstone doesn't refer to any of this in his witness statement. He says, paragraphs 33 to 34, the reasons why they chose to deal with JD and didn't even ask Sports Direct to tender was because the club wasn't aware that Sports Direct had done other similar arrangements with other clubs. Sports Direct doesn't have the premium retail brand experience and negative fan sentiment towards Mr. Ashley, and by association to Sports Direct. But it's quite striking he doesn't refer to this concern about discounting. And can I show you Mr. Nevitt's witness statement, please? Supplemental bundle, page 183. At paragraph 32, he refers to a conversation in mid-December, so just before the order by Sports Direct was placed. And you'll see the discussion with Miss Staveley of the club. She's on the board of directors of the club, and she said that they were worried that, well, let me just read. The club was reluctant to supply Sports Direct with the club kit because the club wanted to achieve certain profit margins on those products, and they were worried that Sports Direct was a price discounter, so that if Sports Direct was supplying club kit, the club would not be able to maintain high prices. And that evidence was not challenged, and it doesn't appear that the Two Circles presentation that I've just shown you, and the reference to the discussion with Miss Staveley, nothing was actually said about that by the club in any of their submissions or evidence, but perhaps more relevantly for present purposes, there's no reference to those matters in the tribunal's judgment. Now, turning to serious issue to be tried, the first point on the test, we've already discussed this to some degree, because we do say the tribunal was wrong in saying no serious issue but directing a trial. But just to add to that, we've not found a single other case where any such decision has been made. We do say it's logically inconsistent.
Well, if you find there's no serious issue to be tried, you'd strike it out, wouldn't you?
My lady, yes, and the club in fact has put a full defence in. So it's very puzzling, if I can say that.
You didn't ask for it to be struck out. I mean, they didn't ask for it to be struck out.
No. My lord, turning to the substantive competition law principles, because we say one of our concerns is obviously on serious issue, that was a reason why the tribunal didn't grant the injunction.
But do they say it's not reasonably arguable? I think I've read something.
They do.
They do. They say it's not reasonably arguable.
They do, as currently
it's
put.
not reasonably arguable. Is that different from the strikeout test?
Well, my lord, we
Summary judgment?
We say it's inconsistent to say no serious issue but triable. And I think as your lordship pointed out, there are, I think, 4 or 5 places where the tribunal says there are matters to be investigated at trial. And indeed, they say they won't get into things.
Well, you would say that to the extent they reach a conclusion it's not reasonably arguable, they do so on the false premise that there were certain factual matters that they ignored because they were contentious.
Yes.
So they've, in other words, they've misdirected themselves across the board.
Exactly. Now, in terms of the substantive competition law principles, because one of our concerns is not only was serious issue a reason why they declined the injunction, but also more substantively on the law, as it were. If this matter is going to proceed to trial, we say that the summary of the principles is erroneous in and of itself. Now, we've set the substantive principles out in our skeleton at 23 to 45, and I just want to draw a few points out. The first point is that this is a very well-known type of abusive conduct, so there's nothing unorthodox. In fact, the case is made clear that there are no closed categories of abuse, and the ultimate question is always whether there's a departure from competition on the merits. But here, as it happens, we're in very much orthodox territory. A dominant undertaking's refusal to supply a downstream competitor. The case law goes back, the seminal case is commercial solvents, paragraph 40 of our skeleton, which dates back to the 1970s. And there are numerous domestic cases which have also considered abusive refusals to supply. For example, at the races, the Burgess case and the Barclays case. And as I've said, often in these types of cases, mandatory injunctive relief is granted because of the nature of the complaint. Now, there's a debate perhaps as to whether a refusal to supply is more likely to be held anti-competitive in the case of existing customers as opposed to new customers. The Commission's guidance, European Commission's guidance, says where you're talking about an existing customer who's cut off, it's more likely to be abusive. And the guidance itself refers to commercial solvents. It's also clear that whether a customer is an existing or a new customer is a matter of substance, not form. And that's why, I think, coming back to some of my lady's questions, we are saying that we should be treated as an existing customer, albeit that the manufacturer may have changed over time. We say, again, applying some common sense, the club has the IP rights, the trademarks to the Newcastle logo. And so in substance, there has been supply from Newcastle to Sports Direct for decades. But a refusal to supply a new customer can also be anti-competitive, where a product or service is objectively necessary or indispensable. And there's a debate between the parties as to whether one needs to show an effect on competition or an elimination of all effective competition, not something that one needs to get into. We say we're actually on the right side of that argument because their argument based on the Microsoft case was rejected by a decision of Mr. Justice Mann in Purple Parking. So that's all. A, we would say that's a matter not for now, but B, we say we're on the right side of that point. But ultimately, what one's looking at is a refusal to supply an existing or a new customer and an effect on competition. And we've pleaded all of that in very orthodox terms, and we've also adduced the CRA expert note. And I'm conscious of time, but to perhaps really emphasise the extent to which the tribunal has departed from orthodox principles, could I just perhaps show you one case very quickly, which is the Burgess Authority. Mm-hmm. It's 2005, but it just conveniently collates a number of cases in this area. So I just want this court to understand that this is very well trodden territory. Burgess is at Authorities 4. It's a judgment of the tribunal back in 2005, but I just want to show you, if we could pick this up at paragraph 291, which is 112 of the bundle. Now, I'm not going to take you through each of these paragraphs, but you can see how much case law is cited by the tribunal.
Where are we, page?
Paragraph 291, my lord, page 112.
Yeah. Yeah.
And so, if I just ask you to cast an eye on that page, but then also all of the references to these European cases going back to the 70s and 80s. 296, for example, prohibited from eliminating a competitor and strengthening its position by recourse to means other than abuse based on competition on the merits. 298. Well, you can take whatever paragraphs you want. 298. A number of cases have dealt with refusal to supply in the context of an alleged abuse of a dominant position. And that's the commercial solvents case again that I mentioned. And you'll see just how much law there is in this area and just how common refusal to supply cases are. And then could I ask the court perhaps to pick this up at 311, so page 119, which is the tribunal's attempt to distill the key principles. And as I say, this is just a convenient, there are many cases, but it's efficient for me just to pick this authority up because it just collates what we say are very well established principles. An abuse of a dominant position, this is 311 subparagraph 1, may occur if a dominant undertaking without objective justification refuses supplies to an established existing customer who abides by regular commercial practice, at least where the refusal is disproportionate and operates to the detriment of consumers. Then you'll see it too.
Well, I mean, you would say, would you, that the question of whether there is objective justification, which plainly the club says there is a question ripe for trial.
Obviously, we say obviously, my lord, because it's heavily fact sensitive, and moreover, the justifications that have been put forward at this stage, we say are incredibly thin.
Well, and whether it's to eliminate a competitor of the dominant undertaking in the downstream market is also for trial.
Exactly, and the effects, my lord, if one looks over the page at 312, one sees if a competitor is substantially weakened but not eliminated, it's not necessarily the case that no abuse has occurred in our view. But here we're talking about complete foreclosure or exclusion from the downstream retail market. Now, we say both the question of effects and objective justification are plainly matters for trial.
And eliminate a competitor means eliminate a competitor from the defined market, and the court accepted, the tribunal accepted, that the confined market was the relevant market.
Exactly, and crucially, Sports Direct is the largest player in that downstream market. If we're right about the market, which the tribunal was prepared to accept was arguably correct, in terms of bricks and mortar stores, there's only JD and Sports Direct. So, with respect, those are the conventional principles. We've included in the bundle an extract from Bellamy and Child, which is the leading textbook, and I won't take up time now by going through that. But that's the case on chapter 2. In fact, let me show you, because Bellamy and Child actually just emphasises the point about the fact-sensitive nature of this type of case. So let me just show you Bellamy and Child in Authorities 2. At tab 13.
Paragraph
It starts at 10.149. You'll see the heading refusal to supply. And you'll see the reference there. The dominant undertaking may be prohibited in the absence of objective justification to refuse to supply existing customers and to grant access to essential facilities on a non-discriminatory basis to new customers. So that's new customers, at least in circumstances where a refusal would eliminate effective competition. And then you'll see the need to balance considerations. And then over the page, you'll see, again, the heading, discontinuing the supply of goods to an existing customer, a reference to the EU jurisprudence, commercial solvents, United Brands, which were picked up in the Burgess case, and telemarketing. And then effect, the next heading above 153, effect of the refusal to supply on the downstream market, commercial solvents and Microsoft, and you'll see at the end of that paragraph, where the refusal is of such a kind as to exclude any effective competition on that neighbouring market without it being necessary to demonstrate that all competition had been eliminated. And then objective justification. And you'll see the commercial rationale for a refusal to deal is not capable of being objectively justified if in reality it's no more than the dominant supplier seeking to reduce or eliminate effective competition. On the contrary, such motivation of the dominant undertaking tends to support the finding of abuse. And then 1055, you'll see refusal to supply new customers can also be abusive. And 156, the meaning of essential facility or indispensability is a fact-specific issue. And 158 over the page, criterion of necessity. Bellamy and Child refer to this as an issue of fact for an individual case. We say that must be correct. And then finally, 159, the effect of a refusal to supply on consumer welfare. The Commission has said that it will examine whether for consumers the likely negative consequences of the refusal outweigh over time the negative consequences of imposing an obligation on the dominant firm to supply. That's a reference to the balancing between the freedom of contract on the one hand and competition law on the other. And we say our case really accords with those principles. Again, I just repeat, what our case boils down to is the club is arguably dominant in the wholesale and retail market, sorry, the wholesale market, but also the retail market, and that is narrowly defined. Whether the club is an existing customer or not has to be a question of substance, not form, but we say it is an existing customer if one is looking at this realistically, having had the kit for decades. It's now been refused supply for the forthcoming season and beyond, presumably, and the effect of that will be to eliminate the main competitor in the downstream retail market, and on the evidence we've seen at the moment, the motivation is because they want to keep prices high. So we say it's plainly a case where the foreclosure, the complete exclusion of Sports Direct will lead to anti-competitive effects and consumer harm. Then the debate becomes, can they objectively justify it? And we say the points that are advanced in that respect so far are incredibly weak, but that will be a matter for trial. And let me show you the expert report, or note, I should call it an expert note, that was put in before the tribunal. That's in supplemental bundle, tab 23, page 201. Perhaps if you look at the first page, just so that you can see this was an economic expert note from CRA. And if I could just direct you to paragraphs, it's section 5, so on 201 of the bundle, section 5.
Simon Chisholm.
Yes, my lord.
Yeah.
Yeah.
I mean, to be clear, the club put in expert evidence itself, but the question here is whether this is arguable and raises a serious issue to be tried. And one can see in section 5 Mr. Chisholm considers our Chapter 1 case, the effects of the exclusive agreement, and then goes on to consider our refusal to supply case. He says a very similar assessment applies as regards the anti-competitive effects. And perhaps it's convenient just to pick up the summary at paragraph 45.
And did the expert on the other side say there was no reasonably arguable case?
I'm not sure he framed his evidence in that way, but he certainly said these arrangements could have pro-competitive effects. That was the line he was taking. But with respect, I'm about to come on to the reasoning of the tribunal on all of this, but it is striking that there's no reference at all to the expert evidence, nor indeed to our pleading, which is completely conventional, the way in which we've pleaded Chapter 1 and Chapter 2 along the lines of the principles I've outlined. No reference in the judgment to the Two Circles report or the motivation that the evidence suggests is behind this decision.
Where is the expert note from the other side?
Tab 28.
Tab 28 of the supplementary bundle.
Page 250.
Thank you.
And there was a reply report, a reply note from Mr. Chisholm as well. At tab 30, my lord.
Section 4 in particular that's relevant at page 261.
So now can I examine the reasoning in the judgment on Chapter 2, taking that first. They accepted the market definition and dominance case, that's paragraph 12, and we say plainly right to hold that that was arguable. But then at paragraph 28, Roman 6, the conclusion on abuse is no arguable case of abuse has been made out. And the core reasoning is contained in paragraphs 27 to 28. And actually, just to pick up the end of 27, the question we must consider is whether a claim for abuse arguably arises on the facts of the present case. So that's the way in which the tribunal has framed the question. And 28 is the key paragraph, and we would make three specific criticisms about the reasoning in 28. But first of all, the list of factors that one sees at 28.3, which the tribunal describes as being material to the question of whether an abuse of dominance has occurred, that shopping list of factors doesn't appear to derive from any case law, nor the Commission's guidance on abuse cases, nor is there any reference to this list of factors in any of the key competition law textbooks. But leaving that point to one side, one only needs to look at the list to see that plainly these are all matters for trial. So we don't accept this as the right legal analysis in line with the cases and the textbooks I've shown you. But even assuming that they are valid, these factors would plainly warrant a trial and must give rise to a serious issue to be tried. That's the first point. The second point is that ultimately the tribunal didn't even rely upon those factors. So when it turns to the facts of our case at 28.4, so 28.4, 5 and 6 is really the key passage where the tribunal looks at the facts of the present case against the background of the principles as it's outlined them. What's clear from these subparagraphs is the tribunal makes a number of points which are erroneous and with respect betray a complete misunderstanding of our claim. So taking 28.4 and 5 first, the tribunal says that Sports Direct is contending, goes on to say that it's abuse of a dominant it's an abuse of dominance for the dominant undertaking to change the manner in which it supplies the market in the future if that change involves ceasing to supply a single undertaking. And then in subparagraph 5, put as boldly as that, we don't consider this proposition to be arguable. And they go on to say halfway through, in order to render this proposition arguable, we consider that something more needs to be shown. But with respect, the claim is not about mere changes to the supply chain or changes to the manufacturer. We're not complaining, as I touched on earlier, we're not complaining about the fact that Castor will no longer be the supplier. Our complaint, as pleaded and as supported by the expert, is about the club's refusal to supply the kit for next season. And as to the suggestion by the tribunal that in order to render this proposition arguable, we consider that something more needs to be shown, well, we say we've manifestly surpassed that threshold because of our expert evidence and the material that was before the tribunal, which one doesn't see referred to here. So to characterise our case as being about the change is incorrect, and also to say that we haven't provided the something more, that's also incorrect. Then, if one looks at 28...
Well, you say it's about a refusal to supply plus no objective justification. Objective justification is a question of fact. Refusal to supply is not contested, and there is no additional pizzazz required to establish that claim, particularly when it's supported by expert evidence as to the market.
Yes, my lord. And I'd add to that, specifically in relation to effects. We had material on effects. So this wasn't a case that was purely pleaded or being pursued in the abstract. Our case did involve producing material to suggest there would be anti-competitive effects.
That's
Consumer.
key.
That's
Key.
That's key, both in substance but also in terms of our criticism of the judgment, because what one doesn't see is any of the material that I've referred to a number of times now.
Yeah.
And so that's the first problem with paragraph 28, the application of the President's principles to the facts of the
What
case.
there is, as I see it, Mr. Singh, is that although the tribunal doesn't refer to either side's theorising, there's expert evidence that you say it has the potential for anti-competitive effects, and an expert on the other side who says it doesn't. And you say that's quintessentially a matter for trial, but at this stage you assume that your expert might be accepted.
Exactly. It's really a short point, but in addition to the process point, as it were, that there's plainly a serious issue to be tried. As I say, we are very concerned about the way in which the principles have been summarised as well, because if this matter were to proceed to a trial on the basis of this judgment, then with respect there's a real risk of a problem, because this just simply isn't the correct legal analysis of refusal to supply cases. Now, that was the first point I wanted to make about the reasoning in 28. The second point is in 28.6.1, Roman 1, you'll see again at 28.6, we consider that no arguable case of abuse has been made out. Roman 1, the expectation of continuity of supply was in this case low. Then they say we've got no clear understanding of the supply position as between Sports Direct and Castor. We don't accept that. But then they say over the page that's a potential fragility in Sports Direct's supply chain that has nothing to do with Newcastle United. And a similar point is made in Roman 3, where they say, for the reasons already given, we consider there was no reasonable or legitimate expectation on the part of Sports Direct of continuity of supply from Castor. Now, we say this is very difficult to follow, this reasoning, in circumstances where Sports Direct has had supply for decades. So plainly, there was a reasonable expectation of continued supply. And if this sort of point wants to be...
Not if they're not if the person who's supplying you is the manufacturer and they're no longer the manufacturer. That's the point that the tribunal's making. It may be a bad one.
Your Ladyship's absolutely right. That is the point the tribunal is making. And we do say that's a bad point, because one has to take a step back and think, Newcastle has the IP to this kit and always has. Newcastle has always permitted supply to occur to the club, to Sports Direct. And so that's why the tribunal has fallen into error in focusing throughout the judgment on the change of arrangements, because our complaint is not about the change of arrangements per se, it's about the club's decision to refuse to supply in a world where for decades that supply has been happening.
Your point is that the decision whether or not to supply rests with Newcastle United, not with Adidas.
Exactly.
I mean, if Newcastle United tell Adidas to supply you, they will.
And exactly, and the CAT actually accepts that point in terms, because it says that Newcastle are the appropriate defendants. Paragraph 13. So we say that this focus on fragility, there's no basis to suggest there was fragility in the supply chain anyway, but we say also they've fallen into error in not focusing on the fact that objectively there has been decades of supply. And then the next problem with 28, paragraph 28, is if one looks at Roman 2, you'll see a reference to we consider the new owners of the dominant undertaking were entitled to revisit the supply arrangements, to consider changing those arrangements. And then at the end of this subparagraph, very difficult to see how the consequences of that substitution can in and of themselves amount to an infringement of Chapter 2. Now, again, that really is not focusing on the substance of our complaint. And it's also difficult to follow, because it seems to amount to a finding that a refusal to supply can't even arguably be abusive where the ownership has changed. It's focusing on form over substance. The undertaking remains the same. It's Newcastle. So, my lord, those are the criticisms of the reasoning in paragraph 28. And then the third main criticism on the serious issue to be tried, the substance of the conclusion on Chapter 2, is the point about consumer harm. I could just direct you to paragraph 29(1).
Can you tell me where your particulars of claim are?
Yes, my lord, they are in the supplemental bundle. Behind tab 15.
It's just the claim form, isn't it?
It's called a claim form, but it serves both purposes, my lord. And the key sections, because obviously we deal with market definition, but the tribunal was prepared to accept that was arguable. You pick it up at paragraph 40, breach of Chapter 2, and then over the page you'll see abuse. And the particulars of abuse, you'll see at A, JD will be the only third-party retailer through which the club replica kit will be available. Refusal reflects to products necessary to compete on the downstream market. That's the narrow market point. The refusal in combination over the page with the exclusivity is likely to lead to elimination of effective competition on the downstream market by foreclosing Sports Direct from that market.
So the two particulars in 43 is the refusing to supply and granting JD exclusive rights to the third-party retailer.
Yes, my lord, but then we go on to plead as particulars the harm that will flow from the foreclosure of Sports Direct from that market. That's over the page. So we refer there to the elimination of Sports Direct, and then D, the refusal is likely to lead to consumer harm.
Yes, thank you.
And
so that was the pleading case.
Yes, my lord, and just whilst this is open, can I just quickly show you what we pleaded in relation to breach of Chapter 1, which is at paragraph 45, because this is all, my lord, very familiar pleading in a case such as this. We say the agreement is going to have anti-competitive effects, and so Mr. Chisholm's report was in support of both limbs of the claim. Now, I was just going to show you paragraph 29. So our third main criticism
of the judgment.
Of the judgment, yes, my lord. The third main criticism of the substantive reasoning on Chapter 2 is the way in which consumer harm is dismissed as being an immaterial point. So at the end of the section, 28 is the application of the law as the tribunal sees it to the facts, and then 29, it follows that the application for interim relief fails at the first hurdle. Then they make three final points relating to the first condition, that serious issue to be tried. Sports Direct contended it was highly material, it was a well-known discounter of prices. We accept this as a fact and proceeded on that basis. But then they say, whilst we accept the factual assertion, we consider it to be immaterial. The fact is that pricing is as much a question of the dominant undertaking's right to determine manner of supply as any other. no unfair pricing contention was articulated by Sports Direct. My lord, that is really just not understanding the case as is pleaded and as was supported by the expert evidence. It wasn't necessary to show that there's an unfairly high price. That's not the particular type of abusive conduct that we're alleging. And I should just say, I think this court has said in the Trains judgment, the Gutman case, paragraph 93, the law relating to abuse is concerned with consumer unfairness. I mean, it's a uncontroversial proposition, that. But where we've pleaded and got evidence that there will be consumer harm, very difficult to see how that can be dismissed as an immaterial...
Sorry, where are you reading? What did you say? What are you criticising? Which
Oh,
bit?
sorry, Mark, 29.1 of the judgment,
29.1.
where the
Okay.
tribunal describes the consumer harm as immaterial.
Yeah, got that.
Now, in relation to Chapter 1, I'll be very brief. That's dealt with or dismissed at 29.3, where the tribunal says they cannot discern any arguable infringement of Chapter 1, but there's no analysis, substantively, of the Chapter 1 case. No reference to our pleading, no reference to Mr. Chisholm's evidence. And again, where the market definition is the narrow one, the effect on competition that we say flows from the agreement is on the market for Newcastle replica kit. And I do make this point, that when resisting the expedited trial, Mr. de la Mare said, and we've quoted this in our skeleton, we are all agreed a full-blown effects analysis is required. But it must follow, with respect, that there is a serious issue to be tried as regards Chapter 1.
What's the reference to that?
The transcript, page 151. Let me find the skeleton reference, my lord. Paragraph 59b of our skeleton, we set that quote out. Because just so that this court is aware, the club's position before the tribunal was not only that there should be no injunction, but also there should be no expedition. And so the submission there in relation to expedition, and I think our suggestion there should be a split trial, Mr. de la Mare was saying, well, we all agree a full-blown effects analysis is required. Now, that's all I wanted to say on serious issue to be tried, and in the next 15 minutes I'll just deal with our three other criticisms. So, adequacy of damages to the club. I can just ask you to turn up paragraph 42 of the judgment. Sorry, 32 subparagraph 3. Yes, I mean, just so that this court is reminded that the tribunal concluded that damages would not be an adequate remedy for Sports Direct. That's at 30 and 31, and it's the subject of a respondent's notice, but I'll perhaps see what Mr. de la Mare says about that. But we say, in fact, what the tribunal has done in relation to the damage to Sports Direct is actually faithfully track the evidence of Mr. Nevitt, who says if we don't have kit even for one season, given that we're the home of football, there will be consequences which are not quantifiable. So I won't take up time on that point. Conversely, we say that the conclusion that damages to the club would be inadequate, we say is not really an assessment of the evidence or an evaluative assessment with which this court cannot interfere. Because if one picks this up at 32.3, the tribunal says that the interim injunction, if granted, would throw a substantial spanner in these delicate and complex works. That's the setting up of the new arrangements. And the fact that we cannot be more specific is, we consider, an indication not that the damage to the club is unreal, but that it is very real but unquantifiable. And then it gives one specific example, which is JD. I'll come back to that. But what they say there is JD's one specific example, but they then go on to question whether in fact JD would be able to allege breach of contract if the supply to Sports Direct is pursuant to an interim order made by the court. But then they go on to say at the end, damage to relations between the club and its suppliers would be very real and impossible to assess. This is a big and important business. the revenues anticipated from this venture are over time likely to be considerable, and they're right to be concerned at the significant disruption. Now, in relation to this, we say there's a problem with the reasoning here, because the only specific example is the reference to JD. But JD, A, it's not clear that they would be able to allege a breach of contract, as the tribunal themselves identify, but B, in any event, JD would be protected by the cross undertaking. So we say that's not a good point by the tribunal in this context, where we're talking about unquantifiable harm. But secondly, the tribunal says it can't be more specific. It actually says that in terms. And we respectfully submit that the reason it can't be more specific is because there was no proper evidence about this. It's simply asserting that there would be a substantial spanner in the works is with respect not good enough. It's not evidence, it's not referring to anything that the club had put forward in concrete terms. But then, in any event, what the tribunal seems to be focused on is long-term disruption that might be caused by an interim order. And the difficulty with that is that, as I've explained, what Sports Direct is seeking by way of interim relief is a fraction of what the club has ordered. So we're not even in a world or a case where we're seeking, the effect of the injunction would be to put the brakes completely on what the respondents want to do. They will actually be able to implement their new arrangements, subject to having to divert some of the orders to Sports Direct. So we say the tribunal's fallen into error in focusing on the long-term business damage. And one sees this in a couple of places in the judgment. It appears at 32.3, but if you look at 34.2 as well, which is in relation to balance of convenience, consider it's important to weigh relative harm to Sports Direct and Newcastle. Damages will not be an adequate remedy for both actors. We consider that greater harm in terms of long-term business damage is likely to accrue to Newcastle. So we say the tribunal was wrong there to focus on the long-term business damage, because what we're actually seeking is an interim relief which would deal with one season's kit and only a fraction of what the club itself has ordered.
You're saying that couldn't cause long-term business damage?
We're saying there's no proper evidence that short disruption, a modest disruption, because it's only a fraction of the kit. We're saying the tribunal says, well, we can't be more specific about it. And we say that's because the tribunal couldn't point to any adequate evidence on that.
You don't really need this point, do you, Mr. Singh?
No, my lady, that's exactly what I was about to come on to, because even if your ladyship's ahead of me, even if the tribunal was right to say damages is an inadequate remedy for both parties, it comes back to status quo. And that's exactly where I was about to
it comes back to the balance of convenience section.
Yes, exactly, my
Part
lord.
and parcel of the same point.
Yes.
Exactly. No, it's balance of convenience. The reason I alight upon status quo, my lord, just to explain that, is because if one...
maintain the status quo, but that's slightly difficult where you're in a situation of change anyway.
No, my lord, you're absolutely right that you ultimately go to balance of convenience, and status quo would be a matter within balance of convenience. But the reason that I direct my submissions on status quo in particular is because if one looks at the way in which the tribunal has dealt with balance of convenience in 34, actually, when one looks through the subparagraphs in 34, one sees that actually the one point that the tribunal says points clearly against the granting of an injunction is status quo in 34.1. The others, you'll see 34.2, relatively little weight on this point. 3, at the end of 3, consumer benefits a neutral factor. We obviously take issue with that. 4, at the end, you'll see the drafting is a minor point. And 5, they reject the clean hands and delay arguments on the basis that those raise factual matters which are for trial.
So clearly in favour is because of the status quo.
Exactly, my lord. Exactly.
You say the state anyway. If we get to that stage, and we can only get to that stage if you're right about serious case to be tried.
Exactly.
Yeah.
my lord. And that's to answer my ladyship's question. I don't need the damages being inadequate to the club, because we get to balance of convenience, even if you're against me on that issue.
Yeah.
Balance of convenience, we say status quo. And just perhaps very briefly, to just remind...
What do you say about the emphasis that is placed on the other side about your failure to give details of the relationship with Castor?
My lord, we say that's a red herring for a couple of reasons. First of all, Mr. Nevitt's second witness statement does explain that the only written agreement with Castor is in relation to Rangers, so different club, and there's a reference in that agreement to Sports Direct's status as a preferred retail partner for other clubs. So there's completely clear evidence before the tribunal as to the fact that there wasn't a written agreement with Castor. The point that Mr. de la Mare focuses on is that under the Castor arrangements, Sports Direct had a 30-day period of exclusivity, and he says that somehow means we don't have clean hands. And in relation to that, the evidence, or the point that I made to the tribunal, was that legally, there's no contractual provision which entitles Sports Direct to 30-day exclusivity. So at best, it was treated as a de facto 30-day period of exclusivity by Castor, the manufacturer. As I said to the tribunal, that will obviously need to be looked at on the facts at trial if the club want to continue to rely upon it. But crucially, it's a red herring for present purposes, because the fact that Sports Direct may have had a 30-day head start, as Mr. de la Mare describes it, doesn't affect what we're looking at here. It doesn't mean that we had the same type of arrangement with Castor, because here Sports Direct have been completely excluded. So it's a totally different beast. That's the first point.
JD had supplies for 5 years.
Yes, exactly, my lord. So we say it's a completely different beast. But secondly, in relation to status quo and so on, I think I said this earlier, it's not right, as he says in his skeleton, that Sports Direct is seeking to perpetuate some advantage that it may have had, because we are not saying we want supply and we want it 30 days in advance. What we're actually looking we're looking to be brought into the position whereby consumers could have gone into either JD or Sports Direct and purchased a Newcastle kit. Just before I sit down, can I remind the court of what the House of Lords, so Lord Diplock in American Cyanamid itself, can I just quickly show you?
Page.
It's Authorities 1, and it's page 408G that I'd like to show you. Page 13 of the bundle. It's just between F and G, where other factors appear to be evenly balanced. It's the counsel of prudence to take such measures as are calculated to preserve the status quo. If the defendant's enjoined temporarily from doing something he's not done before, the only effect of the injunction in the event of his succeeding at the trial is to postpone the date at which he's able to embark upon a course of action which he's not previously found it necessary to undertake, whereas to interrupt him in the conduct of an established enterprise would cause much greater inconvenience to him, since he would have to start again to establish it in the event of his succeeding at the trial. And we say the established position here is Sports Direct supplying the kit. Insofar as the club, what's driving these new arrangements is the club's desire to implement new arrangements. That's not an established enterprise. That's a new set of arrangements. And moreover, as I keep stressing, they will still be entitled to do that, save for some kits that will need to be diverted. So that's the point on balance of convenience and status quo. And then just finally, on consumer harm, could I quickly show you, this is 34.3 of the judgment, but could I quickly show you the extract of Mr. G's book, where he just makes the point that public interest, namely consumers here, is a relevant factor to the just and convenient question. It's in Authorities 2, behind tab 14. And the relevant passage on competition law claims and injunctions is 821 of the bundle. But I particularly wanted to take you to 822, where he says the interests of third parties are relevant to the exercise of discretion on whether to grant an injunction. public interest is relevant to whether to grant an injunction prior to final determination of the merits, compensation in damages paid to a claimant does not compensate the public. And American Cyanamid had no limitation on the factors. And so again, and finally, I do respectfully submit that it's for the tribunal to say at 34.3 that consumer harm was a neutral factor. We say that they were wrong in that respect, and that's something which this court could easily grapple with. It's not a factual point; it's simply an error of principle. Where there's consumer harm and they accepted that there would be consumer harm as a result of this injunction, then we say, as a matter of discretion, an injunction ought to have been granted. Unless I can assist any further, I'm sure I've exceeded my allowance.
No, thank you, Mr. Singler. Mr. de la Mare.
My lord. Clear the decks. It's important in this case not to lose sight of what's between the parties, because in relation to serious issue to be tried, we've heard a lot about how the claimant formulates their case, and that is the correct focal point for that issue. But when one comes to balance of convenience, it's also important to understand how the other party formulates its case. And in terms of the competition law dispute, there is patently a substantial argument for trial about market definition and the correct formulation of its conduct. My learned friend's case is predicated on the analysis from OFT pricing decisions, retail price maintenance decisions, being transposable to this case. And you may have seen in the supplementary bundle what the OFT itself, the CMA says about the safety of that exercise. They make the point that the exercise of market definition for the purposes of investigation of RPM or price fixing is a very different exercise to the investigation of market definition for the purposes of dominance. And so the conclusions aren't transposable. And the OFT, the CMA, are good enough to cite this court in Argos that makes exactly the same point. Now, the relevance of that lies in this basic difference in competition analysis. The defendant's case says there is no such narrow market in relation to a particular club's kit, either at the wholesale or retail level. That analysis would produce absurd results because every single club would be dominant in relation to the
Have you even got a respondent's notice on the courts, the decision of the tribunal below on market?
I'm not suggesting that there's any error in relation to market definition. I'm simply setting out the stall of the parties because it's relevant when one comes to the question of balance of convenience. And it's relevant to understand some of the tribunal's reasoning in relation to balance of convenience, that there isn't simply one worldview of a narrow market, dominance, foreclosure, etc.
So where in the judgment, in relation to balance of convenience, did the tribunal rely on the narrowness or breadth of market?
Well, the most obvious place it's relevant is in relation to the topic of consumer benefit, because the benefit of exclusive agreements in a context such as the present, if there is a wide market, lies in facilitating enhanced competition between JD Sports and Sports Direct. If, as we say, the relevant assessment of the market is one in which retailers compete for footfall through their portfolio of products, and if an exclusivity in relation to a particular product or line of products is a way of attracting footfall, that explains why retailers pay fees or offer benefits to those providing exclusivity. And it explains why, in effect, it's pro-competitive. Because retailers don't compete by having identical lines of products. They compete by the differences in their range. Take a very simple example with a supermarket. Suppose there's a particularly popular branded form of food, let's say Jamie Oliver meals. It may well be the case that a particular supermarket is willing to pay for an exclusivity in relation to that product in order to improve its offer, let's say Sainsbury's relative to Tesco, and thereby improve the footfall and thereby improve the state of retail competition. Now that difference in philosophical approach is very important when one comes to balance of convenience. And my submission is, I'm not going to shirk from defending what the tribunal said in relation to serious issue to be tried, but my submission is that this is a classic balance of convenience case, and that the tribunal's reasoning in relation to balance of convenience, once you understand those rival optics, is unimpeachable. Indeed, my learned friend has the forensic difficulty of effectively showing why it is that the decision of the tribunal is outside the reasonable range of responses, why you should cease to be hesitant, in the word of Lord Diplock in American Cyanamid, and interfere with an evaluation on all the facts.
I mean, do you not accept that if they were wrong about there being a serious case to be tried, we have to consider the balance of convenience afresh on the basis that there was a serious case to be tried?
No, I don't accept that follows.
You don't accept
I don't accept that follows,
Okay.
because the reasoning that comes in relation to balance of convenience is predicated upon all of the relevant issues, the extent of damages, the extent of any shortfall in the adequacy of damages, consumer benefits, etc. It's not predicated in any way on an assessment of the relative strength of the parties' cases.
Well, yes, if the tribunal had stopped short at saying there's no serious issue to be tried, therefore we won't go on to the rest of the cyanamid test, my lord's point might be stronger. But you say, notwithstanding that they found that the threshold hadn't been met, they went on nevertheless to look at every other element of cyanamid, and we are bound to consider what they said about that, although we might disagree with them on the serious issue point.
Correct, my lady. And unless there is a finding that one of the factors moving the balance of convenience is the tribunal's relative assessment of the strength of the claims, which is a legitimate consideration, the passage I invited you to look at in Oland at paragraph 18 shows that it's a relevant consideration, as does Mr. Justice Laddie's decision, as it then was in Software 5.
But why is if we take it at its face value, as Mr. Singler has pointed out, the only thing they actually say points in favour of refusing an injunction on the basis that there was a serious case to be tried is that the status quo is the position after the sale of the club to its new owners and their prima facie right to develop the business according to their rights. For my part anyway, I think that seems perfectly fine. Why is the status quo not also that for the last 20 years or more, JD has been permitted to sell this kit, and it's not going to be, Sports Direct has been permitted to sell this kit, and it's not going to be in the future? Why is that not the status quo, as well as what they say is the position being after the sale?
The position, my lord, is that there is, in effect, no status quo of the kind that Mr. Singler argues for. And that's for a variety of reasons. Reason one, the manufacturer has changed. That is germane, because it is a different undertaking that is engaged in the decision whether or not to supply. The decision previously was the decision of Castor, a separate company with the rights to decide how to conduct its wholesale distribution. The decision is now that of Newcastle. That's the first change. The second change is that there were plainly elements of coziness in the relationship between Castor and Sports Direct and the club at the time that Sports Direct owns the club. And there are two aspects to that. The first, explained in Mr. Silverstone's evidence, is the fairly strange terms of the rights accorded to Castor, which seem to be uncommercial in a number of respects, and for which the evidence, and if we want to play the game of unchallenged evidence, there is unchallenged evidence that the founders of Castor have said that they're effectively embarrassed by the arrangements, but they suited Sports Direct. That's the first element of coziness. The second element of
Embarrassed by the arrangements.
effectively,
Sports Direct.
yes. because they
I'm
appeared
sorry.
one-sided.
I'm sorry to press you. I completely understand that these parties are daggers drawn
Of course.
and that they're making allegations of impropriety on both sides as to the past and probably the future.
Yes.
And whatever we say, they no doubt will continue to do so.
Yes.
But it's a simple question I asked you.
Yes.
Is not the status quo that Newcastle has allowed Sports Direct to sell its kit for many years? That is the status quo, is it not? Through whatever means.
It's well, I was trying to answer
You're
that.
talking
then.
about downstream markets.
I understand the point. The point being made is that one way or another, Sports Direct was able to obtain supply, did obtain supply and sold the kit. And
Yes.
my point is that that is too high a level of generality to investigate the matter. You do need to look at the forensic changes that have occurred, and that leads you to the conclusion there is no status quo of the kind alleged. The first change is a change in the undertaking making the decision as to whether or not to supply. That's a material change.
Well, no, that's not. But that's not what the tribunal has approached this on the basis of the undertaking is Newcastle United. It's not. It's not focusing on Castor or Adidas, because the reality is that if Newcastle, as I put to Mr. Singler, if Newcastle United say to Adidas, 10% of our supplies of our kit is to be supplied to Sports Direct, that's what they'll do. I mean, there's no suggestion that there's some animus between Sports Direct and Adidas, is there?
No,
Or that
no,
Adidas is saying to Newcastle, oh well, we're quite happy to be your manufacturer, but there's no way on earth we're going to permit supply to Sports Direct. It's all in your hands.
Now,
your client's hands.
Now that's absolutely right, my lord. But the point is, when you look at the previous arrangements weren't in my client's hands, because the club had assigned all the relevant rights to make those decisions to Castor. Castor is an entirely separate undertaking. No one has ever suggested otherwise. And Castor made decisions as to what forms of distribution arrangements it wished to enter into. We don't even know the detail of the Castor arrangements because we're not even privy to them.
But why is it too high a level of a generality to say that actually what happened was, by hook or by crook, before the sale, the status quo that we're dealing with is a sale of the club wanting to get back control of its own marketing, which is a perfectly reasonable thing to want to do, and to develop its own business according to its own rights, but against the background that by hook or by crook, in whatever circumstances, Sports Direct has sold the kit for a long time, and so has JD Sport. So that to change that status quo has an effect on the market, whatever the market is, and therefore to maintain that position whilst the tribunal enters into a lengthy trial of all those very interesting competition issues is perhaps not the best idea. That's really the point that's being made against you.
I understand that. And the third point I'd say, there is a material change that suggests that that level of generality of analysis is not the correct one, lies in the nature of the arrangements with Castor and Sports Direct so far as they're discernible. And the issue of the existence of the exclusivity is highly material to whether or not what is being sought is the status quo. Because the position, at least for the last few years, and that is the relevant focus for the purposes of status quo, not the last 20 years, but the most recent passage of supply, the position has been, and there is evidence that is uncontroverted to this effect, and I can take you through it if you want, that Sports Direct, whether or not as a result of a written agreement doesn't matter, as a result of fact, it has enjoyed practical exclusivity for the first month of kit launch, the kit in question.
Yeah.
The parties are agreed that that first month of kit launch is the most vital period. It's the pleaded case of the claimant that 60% of replica kit sales occur immediately after launch. That's the vital period. And it's the sales in that period, as obtained by that exclusivity, that they seek to protect by this injunction.
But I thought that's not the case.
It
thought
is.
Mr. Singler told me, and you tell me if it's wrong, he told me that what he wanted was to get supplied at the same time as the other people with the 50,000 bits he'd ordered.
The level of supply sought, the volume of pieces of replica kit, home, away, alternative strips, shorts, pre-match t-shirts, are identical to the levels of supply obtained from Castor in the last year of the Castor agreement. In other words, what is being sought is precise continuity of volume from the Castor
Yeah, but you
arrangement.
said
not of
with 30 days, not exclusivity.
But the volumes have only been obtained by dint of exclusivity in the month following launch.
Well, maybe.
So it's all
but
very-
all he's asking for. I mean, let's just get this straight, because if we don't understand it properly, then we're going to be deciding the case on a false basis, which is quite wrong. As I understand it, he wants to be supplied either with a percentage or preferably with his order at the same time as other people are supplied, namely Newcastle itself and JD Sports.
Yes.
And he's apparently prepared to take as many shorts and shirts as he took last year, even though on that basis he will not have exclusivity at the moment under the injunction he seeks. Now, am I wrong about any of that?
No, my lord, you're absolutely right. To be clear.
No. That's what you said.
But this
The
is why
vo-
You said you were foregoing exclusivity.
This is why the 30-day point is such a red herring, because we're not seeking to perpetuate, even if that were the position. It's very important to have this straight.
I mean, it's the same quantity as you were previously supplied, but not on an exclusive basis for any period of time.
Exactly right.
Seeking to perpetuate the level of volume that was only obtained by dint of exclusivity.
Well, that with respect, Mr. Delamere, is a classic issue which would need to be
Well, it's
tried
not an
out.
issue.
You may be right, you may be wrong.
It's not an issue with respect, my lord. It's obviously how it works on their own case, because they say that they sell 60% of shirts in the period immediately following launch. The evidence is clear that they are the largest of the wholesale customers of Castor, not, as my learned friend said, the largest retailers on the market. The largest retailers on the market have always been the club and the club store by a very, very large margin. I can give you the percentages if you want. I have to do it on a piece of paper.
Well, we've seen the schedule.
But
It's 350,000 versus 50.
Is there evidence that if they don't have the exclusivity, they can't sell 50,000?
That is axiomatic in circumstances where you're dealing with a product for which there is inelastic demand. Which is what
Is
we're
there
dealing
evidence?
with.
Well, no, because the whole point is that Sports Direct sell this stuff at whatever it is, £7.50, probably a lot more than £7.50.
Well, it's
Whereas the
interesting.
club sells it at £12.50. I mean,
Yes.
that's so I can quite see why people would go into the Sports Direct shop or go online and buy it from Sports Direct rather than from Newcastle
It's
United.
interesting my lord says that, because there's absolutely no evidence that replica kit is discounted in any way differently by Sports Direct from other retailers. Still less is there any evidence that replica kit is discounted in the period of exclusivity. And why would any rational retailer discount in a period of exclusivity where, to that extent, they have a captive market for a product for which there is inelastic demand? The whole market definition case is premised on the fact that Newcastle fans...
Economically, it makes no sense
Makes no
whatsoever
sense.
to discount it during a period of exclusivity.
None at all. It's completely irrational. It would be irrational for JD Sports to pay the very substantial amounts of money that it's willing to pay for exclusivity if it were going to discount. You don't. You use that fact to drive footfall through your shops, and that's exactly the complaint that Sports Direct is effectively making in this case. So the problem with my learned friend, the reason he can't get away from Castor, is that the whole volume of continued supply he seeks is predicated on the old arrangements of exclusivity. the 60% period post-sale is only obtained because everyone else was shut out from the market, and the exclusivity was being policed by Castor, such that when companies like Moon wrote in and said we want the stock, Castor was saying you can't put it on sale until July because of the SDI exclusivity.
So why don't we look at this case on the basis of what he's asking for, and as I understand it, what he asked the tribunal below?
Well, what he's asking for, and this is the reason why, and I know I don't win any brownie points by doing so, it's the reason why I jumped up about the terms of the order. The terms of the order are highly material to inform what in fact he is asking for. Because is he in fact asking for volumes which effectively replicate that which was achieved by exclusivity before? Or is he effectively taking the proffered suggestion of the cat, the judgment of Solomon, and just going for some split the difference notional percentage between the parties?
We
so
find
that
out
gets,
at 2 o'clock.
well, it's very important in my submission.
Well, it
because
puts you in an invidious position because you don't know. Speaking for myself, Mr. Delamaire, I have every sympathy with your position that you don't know what the order is because the case against you seems to be shifting.
It is shifting, and it leads to this basic insight. The reality of everything that my client has done to reorganise its arrangements in these replica areas is that it is effectively taking back control, to use that topical strapline, it's taking back control of its club shop. It's vertically integrating the sale of merchandise replete with its own IP. And what it wants to do is not just take the wholesale profits, but the retail profits from retailing. And the problem my learned friend faces is that that model of club sale is ubiquitous. It's certainly very, very common. It tends to be, the evidence suggests, adopted by smaller rather than larger clubs, but nothing as a matter of competition law can turn on that if each club is a market in its own right for its own kit. That doesn't have any forensic value. There are plenty of clubs that only sell their kit through their kit store. And the logical force of my learned friend's argument is effectively either every club is in fact obliged to sell to Sports Direct, or that once a decision has been taken to sell to Sports Direct, you can never vertically integrate away
But what's
from
the
that position.
exclusive arrangement with JD Sports about?
What's the exclusive arrangement with JD Sports about? It's explained fully in the Two Circles report. Mr. Singler only wants you to look at the last page of the Two Circles report.
Yeah, but what's it about? Tell me.
What's it about? It's about the reasons why it's commercially rational for the club to take back control of operating its store, to win back effectively the retail margin on the sale of the products incorporating its own intellectual property, but to hedge those arrangements to a limited extent with a retail partner who can get to parts that the club store, online and physical presence in Newcastle can't reach. And that is the critical thing, because there's a balanced package. Adidas has an online store, and it has big single brand flagship Adidas stores in London and various other places where the Adidas replica kit's on sale. Manchester United, Arsenal, and now Newcastle. JD Sports also has a network of shops, but there's nothing to be had in investigating the precise number of shops in each place, whether it's 450 versus 400, because the kits are not stocked in every single shop, which is why when you look at the JD Sports agreement, you'll see that there's a much more modest store number requirement as to how many stores the kit has to be sold in, and it's effectively a balanced view about the extent to which your own internal operation and external distribution will reach your fan base wherever it's located. The critical point in all of that is how it feeds into the issue that arose in relation to serious issues to be tried, because we put our case before the tribunal very narrowly on that front. We said the real issue that is problematic from the perspective of serious issue to be tried is whether there is any evidence that there will be elimination of all effective competition. That's the test from the Microsoft case. That is, we say, the binding test that's operative in the circumstances.
That's not what Mr. Justice Mann or the three more recent cases, or Mrs. Justice Rose, as she then was.
We had an argument before the tribunal about the extent to which Mr. Justice Mann has finessed the binding test, and it is a binding test in Microsoft.
Well,
because,
not now, actually, but we could be asked to change it. I'm not saying I'm not encouraging anybody to do it on an interlocutory appeal.
I think that would be a bold submission to go for Section 6.5 and the regulations in these circumstances when no one suggested it. But the putatively binding.
You say CJU is for
General
all purposes binding.
Absolute
General court, is it?
It's general court. There is, in any event, effectively something of an adjectival difference between Mr. Justice Mann and the court, and it's about whether or not it's effective elimination of all competition or something slightly lower but still substantial. The issue between us below on this front was, well, how have you substantiated such a case in circumstances where there are three undertakings, independent substantial undertakings, competing in the very market in question? It doesn't follow that if you add another undertaking in question, Sports Direct, that the market becomes any more competitive. And that was the essential point being made by Mr. Murgatroyd in the passage that I referred you to.
So let me just try and understand this, Mr. de la Mare, if we sort of slow down a bit of the histrionics and get to the bottom of it. You say the real issue is whether, on the serious issue to be tried, is what is now happening eliminating effective competition. It's plainly not, because the club is still selling the goods. The club is allowing another major retailer to sell the goods, and the club wants to take back control, as it's fully entitled to, of its marketing enterprise, as many other clubs do. And if that's the market, that's, as they say it is, then that's the market.
Correct, my lord. And if anything...
So it's not... So just to finish the argument, it's not eliminating competition. It's not even having a serious effect on competition. It's just changing the players.
Absolutely, my lord. And that is why we emphasised and emphasised in our skeleton argument. If anything, there's been an increase in competition.
So
because
why did the tribunal not say it in those simple terms?
I think the source of that problem, my lord, is the way that the case was put below, because it was put below on an axiomatic basis, which is that if I am an existing customer and you refuse to supply me, per se, there's a putative abuse, and then you're straight into the test of objective justification. And with respect, that is wrong.
So you say you don't get to objective justification unless competition is seriously damaged.
Absolutely. And that's a reflection of the fact that just because you're a dominant undertaking doesn't mean that you lose all rights to make business decisions about how to operate your business.
And the reason you emphasise so strongly the first 30 days is Milady's point, that in the first 30 days, discounter or no discounter, they weren't discounting what was only available from them.
Yes, and one sees those types of commercial strategies all over the place, where you only sell yourself for a certain point of time, you take the low-hanging fruit, and then only after that do you...
You put it in the back room and they say, oh, we see if we've got some of that.
Well,
I think
yes, there's lots of marketing strategies about when you release stock and how you release it, all of which are perfectly legitimate.
But your expert made the point for you, because I sort of read ahead of your expert's expert report, and he says, well, there's actually no evidence from the other side in relation to what their discounting strategy, if any, was in relation to this kit, when it was applied, or indeed how much kit was kept in any of their stores.
Yes, the evidence is massively long on we consider ourselves to be the home of football.
Yes.
We're known to be aggressive discounters, etc. But absolutely no evidence about what the actual patterns of sale were in relation to this kit, which is meant to constitute a market in itself. There's no evidence that the Newcastle kit was discounted at launch, thereafter, before Christmas, after Christmas, or whether or not it just conformed to conventional retailing remaindering of stock, where as you get to the end of the product stock life, the stock is remaindered, as the club does, as JD Sports does, as everyone does. There's literally no evidence. And that's...
And 60% is sold in the first month.
Yes.
There is evidence of that.
That's the club's pleaded case.
Yes.
Right.
The Sports Direct pleading case, I think it's paragraph 20 of the claim form. So that's the problem. The problem is there is actually no basis to say that you've got over the hump and into the question of objective justification, because there is no evidence that there's an appreciable effect in competition in circumstances where, on any view, there are now 3 independent appreciable competitors. No one can suggest Adidas is not a real competitor, no one can suggest JD Sports isn't, and no one can suggest that the club isn't. And that's an improvement on the old position, because the old position, the manufacturer and the club shop were one and the same. Castor ran the club shop, Castor was the manufacturer. There was only one undertaking behind both of those outlets. And of course, during the launch period, JD Sports had been excluded along with everyone else. So for the critical launch period, you're looking at a 2 undertaking scenario. So the suggestion that this leads to appreciable effects on competition is utterly unsubstantiated.
Well,
and that,
appreciable adverse effects on competition.
Well,
you say it leads to appreciable beneficial impact
absolutely,
on
but what we're nowhere close to meeting is the Microsoft test of the elimination of all effective competition. It's nowhere close to it. And that, with respect, is really at the heart of what the tribunal is saying is not arguable. When you look at, I think it's 28.4 and the passage my learned friend went to, I agree with him that everything before that is really a run-up and actually not relevant to the central issue. The central issue is actually the conclusion on whether or not an arguable case in relation to that critical issue has been shown.
So if we look at 28.4, with your new lens, Mr. de la Mare, we will see all this explained.
The right bundle, where's it?
I mean, for the avoidance of doubt, I am very receptive to the argument that the CAT is an expert tribunal to which this court should pay considerable respect in matters of competition, which the serious case to be tried is preeminent. So, let's see.
Well, it's also important to understand effectively how the chair was exploring these issues, because that explains some of the references to issues like excessive pricing, etc. Because there was a number of exchanges with Mr. Singler where he sought to effectively identify what it was precisely that was being said to be the abuse. And what is recorded at 28.4, page 36, is effectively where one got to in that exchange, because the tribunal said, well, you accept that changing arrangements aren't themselves necessarily abusive. That was accepted. You accept it's not an abusive pricing case. And that's important because we're dealing with intellectual property, with the inherent monopoly that goes with it. And that's where excessive pricing problems can arise.
But you would say, would you, that 28.4, which is a crucial paragraph,
yes,
I think we can accept, is no different if you say not that it's an abuse of dominance for a dominant undertaking to change the manner in which it supplies the market in the future, but if you said it's an abuse of dominance, it is or is therefore not an abuse of dominance to change the manner in which it supplies the market in the future by withdrawing supplies from somebody who historically has always had them.
That's not an abuse unless it leads to the effective elimination of all competition.
But it's not also, you say it's not also, it doesn't get you into objective justification.
Exactly.
If there is still effective competition in the market.
Exactly so.
Right, that's your submission.
That's my submission.
Where's that in your skeleton, just so that I can find it again later when the noise has died down?
Right near the beginning, as I recall.
I'm not talking about your submissions as noise, I just mean
well, you wouldn't be the first if you did.
It's just that, you know, this case has come on very quickly and we haven't had
it is, and
time as
one of the reasons why I don't shirk from saying that actually at the end of the day this is a balance of convenience case is I have to accept the competition issues are very involved and complicated, and there is lots of case law, and it's not the clearest route through.
It's not strikeable, you say?
No, I say the tribunal's analysis is right, and the answer to the kind of Hobson's choice of how are you saying on the one hand it's not arguable and yet on the other hand you've directed a speedy trial is, the reality is that this was a case pleaded without sight of the relevant agreements, pleaded without JD Sports, and all of that's going to change. There's going to be an amended pleading. We've already been told there's going to be an amended pleading.
Well, hang on a moment. So you accept that to the extent the tribunal has said that there wasn't a serious issue to be tried, that's wrong.
No, I don't accept. I don't accept that that's wrong. I accept that it's not going to be the end of the case.
Well, how can there be no serious issue to be tried, and yet there's to be a speedy trial at some point in
that's the point I was just
later
addressing.
this year? I mean, I just find that rather like how many angels can you get to dance on the head of a pin?
The answer
Either there is a serious case or there isn't a serious case. If there isn't a serious case, there's nothing to be tried. It's a complete waste of time.
I understand my Lord's point. The point I'm making is that the real world is one in which Sports Direct will amend its case as it is going to do.
That's as maybe, but I mean that's effectively saying
that's my answer.
There is an issue, a sufficiently serious issue to be tried that will have to go to trial.
Well, is your answer a different one? Sorry to interrupt.
No.
But is your answer really a different one, which is on the bare facts currently pleaded, there is no arguable, effective, serious effect of...
Yes.
I've forgotten the words, I'm sorry.
Serious issue.
Sorry?
Serious issue.
Serious, no, effective competition.
Elimination of all effective
Elimination,
of all
that's the word I was
competition.
looking for. There is no proper pleading of the elimination of competition. But you expect that they will at least plead by reference to the contracts after disclosure a better case, which is may well be arguable. You can see now it may well be arguable, and therefore you do need to go to the balance of convenience on the basis that it's not strikeable, because the caveat in the authorities, I think it's Lord Hoffman or somebody else, is that you have to look at what might happen after disclosure and by amendment later.
Absolutely.
In a case of this complexity.
Absolutely. And we're practical people. We know that Sports Director, Mr. Ashley, when they get the bit between the teeth, they're going to keep on coming. The case is going to be amended. It's going to
That's
be pleaded.
not relevant.
Well, it's the real world, with respect.
The real world. Exactly.
And that's why we think that the tribunal does have to keep an eye on when the hearing's going to have to be. And that's why it's material, for instance, that JD Sport is going to be brought into the case, as we suggested they always should be, because they're the principal beneficiary of the relevant exclusivity. So,
But you say anyway, the key point is there's no elimination of effective competition. You're going to win on that point in the end. Therefore, there really shouldn't be an injunction, because it's messing up all your arrangements to take back control, which is an expression we can all remember for different and outside reasons. And you should be entitled to do that without interference from the court.
so that's the essence of our case on serious issue to be tried.
Well, it's on both sides of the case, really.
It also comes in, accept that. We also say, by way of our respondents' notice, that the tribunal got the issue of damages as an adequate remedy wrong. That's a very short point.
Yeah.
The short point is we're all agreed that the loss in relation to loss opportunities to sell replica kit can be quantified easily by Sports Direct more than anyone else. They've sold lots of Newcastle kit and lots of other kit. It's not a hard exercise to do. Equally, we're all agreed that working out what sort of level of custom you'd have got from a customer at the same footfall, real or virtual, would you have sold some football boots, etc. at the same time? That's also obviously quantifiable given the rich data they possess. Their case comes down to, and this is very important when you come to balance of convenience, because it's the weight of this point that if there is some kind of uncompensatable loss, is then the main factor in the balance when you get to balance of convenience. Their case is that there's reputational damage, such that there's some kind of unassessable damage to their goodwill with Newcastle.
The home of sport.
Disappointed Newcastle fan really wants to buy some replica kit from Sports Direct, and when he discovers that Sports Direct no longer sells it, he throws his hands up in disgust and goes to buy his everything that he might otherwise go to.
That's right.
Sports Direct from a competitor.
I'm so disgusted with Sports Direct.
Racket from Sports Direct.
I'm so disgusted with Sports Direct for not stocking this football shirt that I'm not going to buy a box for my son's cricket, or the Worcestershire top, or a running top, or some. I'm just not going to shop there again. it's absurd at that general level of
I think they
abstraction.
sell more football boots than they do Worcestershire shirts, but anyway.
Yes.
Well, that says maybe the football boots aren't branded by reference to clubs.
Yet.
Yes.
Yeah.
Trainers, Celtic Sambas, my lady's on the evidence. That's a diffusion item we're keen on, absolutely. But the second reason.
So you say on the serious point about the undertaking in damages and the adequacy of damages is that this is cow cuckoo land. This is 1 month. They had exclusivity. That's what they're annoyed about, and there's no chance in hell that they can't be compensated if they've lost additional trade.
You've got my point on the general plane. There's a point on the particular plane, which is that on any view, the relationship between Sports Direct / Mike Ashley and the Newcastle fan base is toxic. You don't even have to.
Sorry, the relationship between the Newcastle fan base and
Sports Direct and Mr. Ashley
Yes.
is toxic.
Yes.
His ownership, and certainly the end of his ownership, was an unhappy passage in the club. There were boycotts.
It's about as happy a relationship as a Manchester United fan with Mr. Glazer.
Comfortably worse, I would
Right.
suggest.
So we probably know evidence of the latter. My lady's
There
point.
is evidence. Actually.
Is there
There is
evidence of-
evidence of fan satisfaction with the former ownership and how it's changed. There's evidence in paragraph
when-
10 of Mr. Silverton's first statement, in end of his second
It's
statement.
Mr. Silverton, isn't it?
It's all there. There were fan boycotts of Sports Direct during the period of ownership. It even got so bad that they boycotted the club's own season tickets to try to get Mr. Ashley out of the club. The evidence of Mr. Silverton is that there is effectively a deep and lasting antipathy between the fan base and Mr. Ashley. If you ever go below the line on any of the fan sites, you'll see some fairly fruity language.
And that is uncontested.
Well, it is contested by Mr. Nedder, but it's simply...
It's not just contested, my lord. He actually says they sold out all of their Newcastle shirts. It's Nevitt 2, paragraph 20. He says, in terms, they sold out all of their Newcastle kit, Sports Direct did.
Yeah, but there's more than 50,000 Newcastle fans.
comfortably more. The point is this. If you're animated by Sports Direct's history of the club, a fan of the club, you'll have made your decision one way or the other as to whether or not you continue to shop at Sports Direct.
Does that, I mean, I get that point now, but does that actually matter as to the adequacy of damages, assuming that the real question is, can you assess the loss? And your case on that is simply that the tribunal was wrong. You actually can assess the loss. And
Yes, because there isn't a loss.
Well,
There's
the
no
tribunal
there's no-
recognised you could assess. I mean, it had the three heads of damage, if you
Yes.
like. The obvious one, the direct one, the halo effect,
Yes,
both of which they said were quantifiable.
yes,
And then there's third one, which is, I won't buy my son's box
yes.
because they no longer stock Newcastle shirts. And all you're saying, as I understand it, is that that's quite apart from the fact that that's rather a fanciful category of damage anyway. Well, if there is such a loss, it should be capable of being quantified, isn't it?
Well, I say there is no such loss. It's completely implausible on the general plane and given the particular relationship between the fans that anyone is going to say, I'm not shopping at Sports Direct because they don't stock the Newcastle shirt. They're either going to say, I'm not shopping at Sports Direct because I hate Mike Ashley and hate Sports Direct because I'm a Newcastle fan. Or they'll say, well, actually, it's very convenient to me, and notwithstanding all of that, I'm going to go to Sports Direct to buy my son's cricket bat.
Yeah.
The idea that it's going to be impacted one way or the other on the non-availability of shirts is unreal. That's the point.
Yeah, okay.
And we say, once you understand that, you understand that, first of all, damages is an adequate remedy for them. We don't even get to balance of convenience. Or if you do get into balance of convenience, you've basically limped in there on the basis of a head of loss that is, at best, highly tenuous and likely to be extremely modest. So, effectively, all the main loss will be compensated by the prospective damage, and you're left with a small speculative head of loss, which, and this is the critical point when you get to the tribunal's reasoning, it's the second consideration in balance of convenience, which is dwarfed by the loss that is risked to the club by the grant of the injunction. And that is probably where I should go next is now a convenient moment.
Yeah, I'm just looking at paragraph 10 of Mr. Silverson's statement, which is at page 215 in the supplemental bundle.
Yep.
And that is the evidence about the extent and depth of the negative feeling among the club's fan base towards the previous ownership epitomised by Mr. Ashley in Sports Direct.
That's from his first witness statement. He then responds to Mr. Nevitt's witness statement.
Well, and I mean, for my part, I don't really want to get into the detail of it. Is it disputed that there is that antipathy?
I don't think
on the evidence.
I don't
Does
think
somebody put in a witness statement saying there is no antipathy? They all love
I
it.
don't think that I think the case.
Rather
please,
than Mr. De La Mare answer that, can I show you the evidence? Because it's Mr. Nevitt's
Just
second.
give me the reference.
It's paragraph 20 of Mr. Nevitt's second statement, page 440.
440.
His second statement is at 280. Tab
280.
No, I'm sorry, it's
284.
284.
Tab 20.
284. Paragraph
20.
Yeah. Oh yes, there is evidence. So it's a contested fact.
We say it's massively overstated, this antipathy point.
And then it's responded to at tab 33, Mr. Silverson's second witness statement, page 308 to 309.
'23.
33, ST's reputation with the club's fans, 18 and onwards. He addresses paragraph 20, which Mr. Singler has just
Yes.
and it deals with the boycotts, etc., the Premier League fans' match day experience, and so on and so forth. Now,
It's
this,
hotly contested.
it is contested, but the important point to realise is that this goes to both adequacy of damages and balance of convenience. And there is no impediment to the tribunal forming a view as to what they think the likely strength of the case is in relation to those elements.
Yes. I mean, this is the thing that I found remarkable about this decision, if I may say so, and I want to put it to you anyway, so we can deal with it after lunch. The tribunal seems to be saying anything that's contested, I don't take into account. But the rule is anything that's contested is acknowledged as contested, but may well be taken into account. First of all, as far as the claimant's case is concerned, you assume that they can prove what they set out to improve unless somebody has produced evidence to show it's flatly wrong.
Absolutely, my lord. If you like, the summary judgment test
But
runs up to, but only up to, serious issue to be tried. And thereafter, you've got Olint, paragraph 18, saying one of the factors that affects balance of convenience is the assessment of the relative strength of the case. You've got the masterful judgment of Mr. Justice Laddie in Series 5 software, unpicking all the myths about American Cyanamid to explain that there's very wide entitlement to look at the underlying merits.
Have we got that in the bundle?
yes.
Yes, it is, yeah. It is a masterful judgment.
This is very
Okay.
And the point I make in relation to assessment of damages is that this is an area where you can and should, because it's both relevant to question 2 and question 4, form a view as to the relative strength of the party's case. And my case is very simple. The case for damage being suffered that's uncompensatable is wafer thin. By contrast, my clients are at risk of being in breach of critical commercial contracts with all kinds of ramifications, both in those commercial relationships and in relation to areas like football finance, which impacts potentially upon how they compete, what players they buy, etc. That was
So I mean, I get all that, but the one point you, I think, do accept that Mr. Singler made, and I prompted him to make it, which is that there was a wrong approach to the assessment of contested fact.
in relation to adequacy of damages and in relation to balance of convenience, we accept that you can and must, if you think it's appropriate, if the lie of the evidence is right, you must take a view on the merits.
But also a serious case to be tried. You can't ignore the claimant's case.
You
because
can't,
it's
no,
contested.
you have to make an assessment
Yeah.
as to whether it's fanciful or...
Yeah, it's fanciful. Of course, you do ignore it. Okay, That's very helpful. Mr. de la Mare, we'll see you again at 2 o'clock. Thank you.